Good afternoon and welcome to the Supreme Court of Florida. We have one case on our docket today, CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Thank you, Chief Justice Rao and honorable justices, and may it please the court. My name is Owen Bader-Schneider, and I, along with my co-counsel, Ms. Rubina Torquezada, represent the petitioner, CBA, in today's case. I will be addressing the issue of free speech, and Ms. Torquezada will be discussing the issue of unreasonable search. At this time, we would like to reserve 2 minutes for our rebuttal.
So noted.
Your Honors, how did a high school basketball tryout turn into a criminal offense? After CBA failed to make the varsity basketball team, she took to her private Instagram account to express her own opinions. She was then charged under Statute 836.15 with cyberbullying. However, this criminal charge violated her First Amendment rights. For that reason, we ask the court to overturn the ruling of the 7th District Court of Appeals for 2 reasons. First, CBA's speech does not fall into a regulatable category of speech. And secondly, the government's interest in regulating cyberbullying is not applicable in this instance. Your Honors, there's an abundance of legal precedents that prove CBA speech shouldn't be subject to regulation. In Tinker v. Des Moines, it was ruled that a student does not shed their rights at the schoolhouse gates. The Supreme Court has determined that schools can regulate speech that materially disrupts the learning environment, but Statute 836.15 does not prevent speech that disrupts the learning environment.
Well, it could possibly, right? It's a fairly broad statute that deals with everything from threats and physical violence to teasing. I mean, it's a pretty wide swath, and some of that seems that the state fairly clearly has a compelling interest in. Correct? Things that are physically violent or things that are intimidation or threats. If she would have threatened the coach, the life of the coach, after getting cut, that would have been a different situation, I would guess.
We do agree that that would have been a different situation, Your Honor. However, in this instance, CBA speech, like you said, it was very broad and was still punished under this statute. In this instance, we believe that it shouldn't have been punishable. Additionally, the Supreme Court outlined in Mahanoy 3 areas in which the schools can regulate speech. The first of those areas is any vulgar or lewd speech. The second is any speech that promotes illegal drug use. And the third is speech that bears the imprimatur of the school. CBA speech does not fall under any of these 3 categories. It does not promote illegal drug use, and it does not bear the imprimatur of the school.
But that was, are you suggesting the Supreme Court gave an exhaustive list in those 3 categories? Didn't the court in Mahoney go on to reaffirm its holding in Tinker that you can regulate speech if it poses a substantial disruption to the classroom?
That is correct, Your Honor. However, the state does not believe that CBA's comments did provide a substantial disruption to the classroom.
And I understand that argument, but do you concede, though, that that is an area where the state can regulate?
We do believe that the state can regulate material disruptions, yes.
Okay, thank you.
Is that a fact question about whether there was a substantial disruption? So the number of students walking out of the class, I mean, was that within the trial court and the 7th DCA's discretion to determine whether there were facts to support that there was a substantial disruption?
It is not, as the fact pattern goes, we are only aware that the members of the basketball team walked out of the classroom. As far as any other disruptions, the fact pattern does not contain that.
But is that a question of fact that the trial court gets to resolve, or is that illegal, when something rises to the level of the substantial disruption?
We believe that that would be a legal question. However, we believe that CBA's speech would not meet that requirement. We also believe that this was a content-based restriction, therefore should be subject to strict scrutiny. We believe that this does not meet the requirements for strict scrutiny as outlined in Flanagan Enters v. Fulton County. In that case, it outlines that there must be a substantial government interest and that the statute must promote that government interest. However, on page 3 of the record, it states that the Florida legislature's intent with this law was to limit cell phone usage in classrooms. However, this only prohibits cyberbullying, not cell phone usage in classrooms. Therefore, we believe it to be not to meet the burden of strict scrutiny. We also believe that if the law was, the intent was to limit cell phone usage, then all of the members of the basketball team who went on their phones would have been punished under such statute. Therefore, we believe that it is not narrowly tailored to achieve its interests in that manner.
Why isn't it narrowly tailored? Because it does, it obviously targets teasing, social exclusion, threat, intimidation, but only those actions that inflict physical or psychological distress on one or more students. So why doesn't that aspect of it, kind of the tail end, satisfy the narrowly tailored aspect?
We believe that the term psychological distress is very broad, as there could be many different forms of psychological distress that could fall under that, and would be too broad to narrowly tailor to the government's interests. And again, the government's interest would not be regulating cell phone usage in this instance, as the state legislature purports. For those aforementioned reasons, we ask this court to overturn the ruling made by the 7th District Court of Appeals in favor of Petitioner.
Thank you, counsel.
Chief Justice, Honorable Justices, my name is Rubina Torxade, and today, on behalf of the petitioner, CBA, I will be addressing the second issue of whether the warrantless search of the petitioner's phone on school property violated their state and federal constitutional rights to be free from unreasonable search and seizure. There are two reasons why we are asking this court to reverse the decision of the 7th District Court of Appeal, as the warrantless search of CBA's phone was indeed a violation of their Fourth Amendment rights. First, in contrast to the specific exceptions to the warrant requirements as established by Riley v. California, there were no exigent circumstances to justify the warrantless search of CBA's cell phone and private Instagram account. Second, the cell phone is a trove of personal information as established by State v. Casey, which does not qualify the search of CBA's phone to be conducted solely on the grounds of reasonableness. Riley v. California establishes that the need to prevent imminent destruction of evidence qualifies as an exigent circumstance, which
Isn't that what we have here, that there's the potential that if the defendant gets the phone, that they can eliminate the content?
No, Justice, there is no such circumstance in this case to justify the warrantless search of CBA's phone. There is evidence of CBA's posts automatically stored to the cloud, and it could be accessed by school officials at any point during their investigation.
You make a point I was actually just about to ask about. So under Riley, when can there be exigent circumstances to search a cell phone? When might there be a danger of imminent destruction?
There can be a danger when that person is able to alter or modify the evidence, as might have been the case in this situation, but it is not, because that post is preserved.
Is there a difference maybe between an application that's in the cloud versus something that's just on the phone? So a photograph that hasn't been uploaded to the cloud might be able to be destroyed, but here, is that an important distinction that we should look at?
Yes, everything on Instagram is uploaded to the cloud, so that would be a distinction. But in this case, since it is preserved, it should not be a matter that should be dealt with.
Is there a sense in which that in these types of cases we are requiring school officials to be experts on all of these apps that are out there, and they may not know what can be permanently destroyed and which may not? Some may not, and so therefore there's some leniency there as applied to school officials in seizing this evidence.
Yes, however, school officials were aware that the followers of CBA's account also had access to the post, and therefore they were able to preserve the post as well. In fact, a parent submitted a partial screenshot of the post to the school principal, and therefore the investigation of the allegations against CBA could have been done entirely through the use of voluntarily provided information. And there was no legitimate need to actually search CBA's phone. Both the United States Supreme Court and the Florida Supreme Court have acknowledged the definition established by State v. Casey that the cell phone is a trove of personal information, unlike any static object that can be searched incident to a lawful arrest. Therefore, we would contend that the warrantless search of CBA's phone does not apply to the two-part standards of reasonableness as established in New Jersey v. TLO, which determines if a search of a student's property by school officials is a violation of the Fourth Amendment. In New Jersey v. TLO, the search of a student's purse was justified under the grounds of reasonable suspicion. The search of a purse is distinctly different from that of a cell phone, and due to the extent of personal information contained on a cell phone, the standards of reasonableness in TLO does not apply to this case.
Is there any evidence in the record that school officials looked for anything beyond the Instagram account in searching the cell phone? I mean, is it more like akin to a purse? They opened it up, they looked at the Instagram account, and then they got out.
In this case, the record does not state whether in finding through the process of searching the phone to find the Instagram account, it does not state whether they searched other aspects of their phone. Therefore, it would be a threat to CBA's privacy.
Would your argument be different if the state did produce evidence that the only thing school officials looked for after they gained access to the phone was the Instagram account?
Yes, it would be different in that case. Under State v. Casey, a warrant is required to search a surrendered and password-protected cell phone. After CBA surrendered her phone to school officials, a warrant was required to complete the search of its contents. At that point, there was no threat of destruction of evidence, since the phone was in the hands of school authorities. Because the tip from the parent of the basketball team did not provide sufficient probable cause for authorities to obtain a warrant, the CBA cell phone should have never been searched.
Did she consent to the search?
There is no record that CBA consented to the search, and as a minor, CBA could have been coerced into handing over the password to her cell phone. For those aforementioned reasons, we ask this court to reverse the decision of the 7th District Court of Appeal. Thank you.
Thank you, counsel.
Madam Chief Justice, Honorable Justices, and may it please the Court. Good afternoon. My name is Taeyoung Kim, and along with my co-counsel Charlotte Wu, we have the pleasure of representing the respondent, the state of Florida, in this matter. Of the two issues before the Court, I will be addressing the first, which is whether the application of Florida Statute Section 836.15 to the petitioner's conduct violated her state and federal constitutional rights to free speech. We are here today to ask this honorable court to affirm the decision of the lower court in denying the petitioner's motion to dismiss for the following two reasons. First, Florida Statute Section 836.15 is facially constitutional under the First Amendment. And secondly, the application of the statute to the petitioner's conduct did not infringe upon her First Amendment rights. First, Florida Statute Section 836.15 is facially constitutional. The First Amendment of both the federal and Florida state constitutions recognizes the rights of citizens to free speech. However, that right is not absolute. Not only have the courts narrowly defined certain categories of unprotected speech, such as incitement, obscenity, or true threats, but additionally, and most paramount to this case, the Supreme Court carved out a separate exception specifically for students more than 50 years ago in Tinker versus Des Moines. And a key distinction that I would like to make here that the respondent failed to articulate is that not only did the Supreme Court carve out an exception for conduct by student that materially disrupts the classroom environment, but additionally for conduct by student that involves a substantial disorder or invasion of the rights of other students.
Counsel, does the Tinker analysis really apply here because we're dealing with the criminal statute? Tinker, if I recall, dealt with an administrative procedure, a suspension, disciplinary conduct. So why shouldn't we look to more traditional First Amendment principles to resolve this case?
Well, Justice Ray, it is true that the punishment in both Tinker and Mahanoy had to do with school administrative policies. However, there is still a compelling government interest in both preventing disruption to the classroom environment and protecting the rights of students. And it's our contention that through the enactment of this statute, it's clear that the Florida legislature listened to the decisions of the court in both Tinker and Mahanoy, and through the enactment of this statute, they intended to limit the type of content that the Supreme Court specifically outlined could be constitutionally restricted under the First Amendment. And to address—
Is there really a compelling government interest to limit teasing in school? I mean, it seems like even amongst the best of friends, teasing goes on constantly. And so does this statute basically put everybody at risk all the time? It's just a matter of having somebody come and make a charge against one, and does that implicate some overbreadth problems?
Well, Justice Osterhaus, that is certainly a concern, especially considering that the statute does prescribe teasing as one of the illustrative examples of what could constitute psychological distress. However, in accordance with the analysis by the court in the Pennsylvania Supreme Court in the interest of JJM, we have to look at both the subjective and objective contextual circumstances surrounding the challenge statement. So we would look at these things on a case-by-case basis. However, in regards to the statute on its face, it does specifically prescribe that the harm must be physical or psychological distress, it must be to students, and the examples are just illustrative examples that could constitute psychological distress upon analysis.
And counsel, is it objectively reasonable for a basketball team to have psychological distress when someone says that they suck or that they're bad? I mean, isn't that something that fans scream from the stands when they're losing?
Yes, Chief Justice Rowe, that's certainly a concern. However, in the instant case, when we take a look at both the speaker's subjective intent on what she was doing through her post, but additionally, we have to look at the objective contextual circumstances, namely not only the nature of the post, but as laid out in the interest of JJM, the actual reaction of the listeners and the other people who saw the intended post. And we see here that not only did the petitioner have a subjective intent that was somewhat ill-formed, considering that she not only specifically called out the basketball team, but she did so on a public platform where she was intentionally disseminating that information. But even if she didn't particularly intend to inflict physical or psychological distress upon those students, that is precisely what happened.
Well, counsel, let me ask you this. I mean, what I'm struggling with is if CBA had been in the stands of the basketball game and said, you all suck, that would be protected speech. But if she posted on Instagram, it's a criminal violation.
Yes, Justice Rowe, that is certainly a concern. However, if we take a look at the fact that using social media, she was purposely disseminating it to a public audience, whereas in a school gymnasium, say if she had said the same statements, it would likely be more a reflection of her immediate opinion about the basketball team. However, particularly in the instant case, if we take a look at what actually happened as a result, it was not the result of one sensitive basketball player being so offended by their post that they walked out, but it was actually several members of the basketball team who not only walked out of their classrooms during instructional time, but also posted to their own social media accounts that they were quitting the basketball team as a result. And but for the petitioner's conduct, we would not have seen that immediate disruption to the classroom environment, and we would not have seen the continuous viral post that happened as a result, the thousands of views, the hundreds of comments, and the viral hashtag of basketball sucks that circulated the school community as a result of the petitioner's conduct. So even though we consider that perhaps the petitioner was expressing her opinion to a certain degree, the objective contextual circumstances include the actual reactions of those students, especially considering that these are juvenile students who are certainly at an impressionable age and might have a more severe reaction than those of adults.
But the petitioner couldn't control what other people did. I mean, so if she just posted this and just walked away and she's done, whether she gets prosecuted now depends on how many other people react and retweet or, send out a hashtag. Is that right?
Well, Justice Rowe, it is certainly a concern, and it's respondents' contention that in addition to the fact that the petitioner certainly had an intent to disseminate harmful information about the basketball team, on a case-by-case basis, we have to also see what result that actually produced. And the fact that multiple students felt so offended and so lacking confidence as a result of the petitioner's post is an indication that in this particular case, her conduct did rise to some form of psychological distress and a type of cyberbullying that the courts have long held the schools do have an interest in preventing.
Well, counsel, just real quickly on that point, because Petitioner argued that, and persuasively, that there's a disconnect between the express legislative intent here, which is to prevent a substantial disruption of school, and we know from Tinker that that is a compelling state interest, but cyberbullying doesn't necessarily have anything to do or necessarily a connection with a disruption in class. So could you help us connect the dots there?
Certainly, Justice Ray. Not only is a substantial disruption a concern, but the invasion of the rights of other students to a safe learning environment is also certainly a concern. And with carving out that there must be physical or psychological distress, we believe the Florida legislature did exactly so. It's for these reasons we respectfully ask this honorable court to affirm the decision of the lower court in denying the petitioner's motion to dismiss. Thank you.
Thank you, counsel.
Madam Chief Justice, honorable justices, and may it please the court. Good afternoon. My name is Charlotte Wu, and along with my co-counsel, Taeyoung Kim, we have the pleasure of representing the respondent in today's case, the state of Florida. As my co-counsel has just presented respondent's argument in regards to issue 1, I will be addressing issue 2, which is whether the warrantless search of petitioner's phone on school property violated her Fourth Amendment rights. We are here today to ask this honorable court to affirm the lower court's decision in denying the motion to suppress for the following 2 reasons. First, the search of CBA's cell phone passed the 2-part reasonableness test established in TLO. And second, the school officials met exceptions to the warrant requirements. In protecting people's Fourth Amendment right against unreasonable search and seizure, government officials are required to obtain a warrant before they conduct a search. However, more than 30 years ago, the U.S. Supreme Court ruled that school officials have the ability to search a student's belongings on school property without a warrant, as long as that search is reasonable. As such, in New Jersey v. TLO, the Supreme Court established a 2-part reasonableness test comprised of 2 requirements. First, that the search was justified at its inception, with reasonable grounds for suspecting that the search would turn up evidence that the student has violated or is violating either the school rules or the law. And second, that the search was reasonably related in scope to the circumstances that justified the interference in the first place. Beginning with respondent's first reason, the school officials met the TLO test. The search of the cell phone passed the first prong. Despite the fact that the principal already had a partial screenshot given to him by the parent, the school officials still had a need to verify that the Instagram post was in fact made by CBA, which justified the search of the cell phone at its inception. It was reasonable for the school officials to conduct a thorough search before taking complete action. And further, the school officials had reasonable grounds to believe that CBA's phone contained access to her Instagram account, as the phone is an obvious place for a social media account to be, just like the purse was an obvious place for the cigarettes to be in TLO. Second, the search of the cell phone also met the second prong. The search of the cell phone was reasonably related in scope to the circumstances that justified their interference in the first place. Page 2 of the record reflects that the school officials searched the content of CBA's phone for access to her private Instagram account as evidence, which is indicative of parameters that were delineated for such a search.
Why wouldn't the standard be higher because all this was done under the guise of a law enforcement officer? I mean, why wouldn't it be probable cause instead of reasonableness?
Yes, Justice Osterhaus. Although the record does reflect that the school resource officer also searched CBA's phone, it is respondent's contention that because the school resource officer conducted the search under the direction of the principal and in conjunction with the principal, that the school resource officer was not acting in traditional law enforcement function, but rather as a school official. And as such, the school resource officer can still have a reasonable search under the lower standard of reasonable suspicion. Directing this court's attention back to the TLO test, both of the prongs were met. However, if this honorable court finds that the search of the cell phone did not pass the 2-part reasonableness test, the search was still reasonable because the school officials met exceptions to the warrant requirement, one being exigent circumstances. In Kimmel v. California, which is cited by Riley v. California, one such exigent circumstance is the need to prevent the imminent destruction of evidence. In the incident case, page 2 of the record reflects that there were subsequent comments and posts made in response to CBA's initial post, which each went viral. As such, it was reasonable for the school officials to believe that once CBA caught wind of those subsequent posts, that she would want to delete her post. And because of today's digital age, the evanescent nature of cell phones, and the technological capacity that allows an Instagram post to be deleted with a few clicks in a matter of seconds, it was most certainly reasonable for the school officials to have reasonable grounds to believe that there was an imminent danger of CBA deleting her post.
Is it the state's argument that there's no cloud-based backup for these posts for Instagram?
Yes, Chief Justice Rowe, that is respondent's contention in the instant case. Because the Instagram post was about to be deleted by the petitioner in the instant case, the school officials had reason to believe that there were exigent circumstances. And once that post was deleted, there would be no other record of that post other than the partial screenshot that the parent preserved. However, it is respondent's contention that that partial screenshot was not enough evidence to be preserved, as it was not in its entirety and did not include the account name.
Is our concern here more about what a reasonable school official might think about how the technology works? Given technology is evolving, there's always new apps, what have you. I'm sure school officials aren't up to date with all the apps and everything. So it could be that in actuality, this evidence was available all sorts of places. What is the driving force behind how we decide it? The fact that there is other places they could have got it, or what was reasonable in their what was reasonable given that they're school officials, they're not techies?
Justice Osterhaus, to answer your question, as Your Honor previously pointed out during petitioner's oral argument, given the fact that the school officials may not be exactly caught up to date on technology, the school officials should most certainly be granted some leniency in the instant case. As established by the court in Kentucky versus King, there does not need to actually be exigent circumstances as long as the school officials had reason to believe that there were exigent circumstances. And in the instant case, because of the inherent nature of a cell phone, even if there were less intrusive means or other ways that the evidence was preserved, as long as the school officials had reasonable grounds to believe that there were exigent circumstances, then their search was reasonable. And in Kentucky versus King, the police officers both went into the wrong apartment room and found the wrong person. But the court still held that the police officer's search was reasonable because the police officers had reason to believe that drug-related evidence was about to be destroyed. And the facts and circumstances of the instant case are most certainly comparable to King. And finally, the petitioner gave consent in the instant case. In State versus Thomas, the court established an objective reasonableness test when measuring the standard of a suspect's scope for consent. And this objective reasonableness test measures what a typical reasonable person would have understood by the exchange between a suspect and an officer. Here, petitioner was very clearly told by the school officials to unlock her phone, and she had every opportunity to refuse to do so, but she did not.
But remind me of the facts in Thomas. Was there a request in that case, or was there a directive like we have in this case?
Yes, Justice Ray. In State versus Thomas, the police officers did explicitly ask the defendant if they mind that they search their phone. However, in the instant case, a specific request is not required in order for consent to be established. It is respondent's contention that a high schooler like petitioner is of the age to understand what the school authorities were asking her to do.
But why isn't the school situation unique? Because there are two regimes hanging over the student's head, right? There's a criminal regime, very serious, but there's also a school regime that, hey, if you don't let us go here, we've got this that has a much lower standard, and we can hammer you with it.
Yes, Justice Osterhaus, despite those concerns that Your Honor just expressed, it is still respondent's contention that the petitioner did consent because given today's day and age, and presumably a high schooler of petitioner's age that constantly uses her phone, she did understand what the school officials were asking her to do, and she had the opportunity to withdraw or object or limit her consent, similar to Appellate versus State, but because she did not, it is respondent's contention that she did consent. And for all these reasons, we respectfully ask this honorable court to affirm the lower court's decision in denying the motion to suppress. Thank you.
Thank you, counsel.
Honorable Justices, please do not be misled by the respondent's argument that Statute 836.15 promotes the government interest of limiting classroom disruptions. And the classroom disruption in this case was the students walking out of the classroom. That was solely the decision of those students. The blame should not fall on the shoulders of CBA, as her post did not incite them to walk out. It was solely their decision. If anything, the blame should fall on the basketball team themselves. As far as the Fourth Amendment goes, there is no evidence to suggest that CBA wanted to delete or alter the post in the record. However, if there were exigent circumstances, the school officials could have detained CBA while they obtained the warrant to search her phone, and we wouldn't have to be here today. For those aforementioned reasons, we ask this court to reverse the decision made in the 7th District Court of Appeal.
Thank you, counsel. Thank you all. This court is adjourned. Good afternoon. Welcome to the Supreme Court of Florida. We have one case on the docket today, CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Chief Justice Rowe, honorable justices, and may it please the court. My name is Lindsay Browner, and today I, along with my co-counsel, Anna Schulman, represent the petitioner, CBA. Of the two issues before this court today, I will present the first, how Florida Statute 836.15 is a violation of the First Amendment's guarantees for 3 reasons. First, Your Honors, the statute is content-based. Second, it is unable to overcome strict scrutiny. And third, it is unconstitutional as it was applied. First, Your Honors, Florida Statute 836.15 is content-based. If I could turn Your Honor's attention to page 1364 of the case U.S. v. Fleury, you'll find that a content-based regulation distinguishes favored speech from disfavored speech on the views or on the basis of the ideas expressed. And Your Honors, that is exactly what we're seeing here. The Florida statute keeps legal speech that it does not deem to be cyberbullying, but other types of speech it prohibits. Your Honors, since this statute is content-based, it must overcome strict scrutiny, which, as laid out on page 178 of Miles v. Edgewater, has 2 prongs. The first prong is that there must be a compelling governmental interest, which we do concede that there is. If I could turn Your Honor's attention to page 2, paragraph 2 of the record, the Florida legislature determined that use of cell phones by students during the school day was causing a disturbance and needed to be fixed. However, Your Honors, what we take issue with is the second prong of strict scrutiny, that the statute must be narrowly tailored. If I could turn Your Honor's attention to the case of Burley v. City of Key West, on page 979, you'll find that a statute cannot overcome strict scrutiny unless there is sufficient evidence that it will actually further the governmental interest that it propounds.
What part is too much? It makes this over broad.
Yes, Your Honor. It's not necessarily what is in the statute, but rather what isn't. If I could turn Your Honor's attention to page 3, paragraph 4 of the record, you'll find a copy of the statute where there is no intent requirement included in the statute. Now, what makes this overbroad is the fact that because of a lack of intent, this statute could include positively intended messages that then are received in a negative way, but are criminalized because of how they are received. On the flip side, messages that are intended in a negative way, but maybe aren't received in that negative way, are not punished under the statute.
Doesn't that actually go against your argument that this is a content-based restriction as opposed to a content-neutral restriction? In other words, it seems like what you were just focusing on then was the impact of the statement and not, whether some speech is favored over another type of speech.
No, Justice Ray. Although this statute in itself does look at the impact to determine if some behavior does or does not violate the statute, the actual statute itself and the goals of the statute are to limit certain types of speech as opposed to other types of speech. In this case, allowing speech that it does not deem to be cyberbullying, but other types of speech, which it may allege falls under one of those categories, is prevented, which is what makes the statute content-based. Additionally, because of this lack of mens rea found within the statute, there creates no distinction between criticism and bullying. So in some instances where, per se, a coach is criticizing their teammates on how to do better and how to improve, if the students are offended, that could fall under the statute. And this lack of distinction between outright bullying and criticism by a coach intended in a positive way is a clear example of how the statute is overbroad because it does not take any mens rea into account. Additionally, Your Honors, we would allege that the statute constitutes a prior restraint on any sort of opinions alleged online. If I could turn Your Honor's attention to the case of Fox v. Hamptons at Metro West on page 456, you'll find that a blanket protection of online speech constitutes an unconstitutional prior restraint on free speech, which is the most serious and the least tolerable infringement on First Amendment protections. Due to the fact that an opinion on any topic has the ability to offend students and make them feel as if they're being psychologically abused by these words, any opinion is capable of falling under the statute, meaning that this statute then becomes a prior restraint on any sort of opinion content used online ever. Finally, Your Honors, Statute 836.15 is unconstitutional as it was applied. Your Honors, in this case, there was no substantial disruption to justify the school's action. If I could turn Your Honor's attention to the case of Mahano Area School District VBL, on pages 2047 to 48, you'll find that there was a multi-day disturbance, as well as students who were visibly upset, which did not amount to a substantial disruption. Now, the disturbance seen in today's case, on page 2, paragraph 2 of the record, was a single-day disturbance and a lack of confidence within people on the basketball team. This disturbance does not even come close to the level of disturbance found in Mahanoy, which even the disturbance in Mahanoy
Yeah,
was
but
found
the
in
pulling of a fire alarm or a fire at a school is also could be a one-day disturbance, right? Everybody flees the building, and it's still a serious it's a serious thing and something to be run from.
Chief Justice Rowe, I see my time is about to elapse. May I briefly answer Justice Osterhaus's question and then conclude?
Yes, you may.
Thank you, Your Honor. In this case, the pulling of a fire alarm, for example, would be a disturbance affecting the entire school, whereas the disturbance seen in today's case is simply affecting the few students who are on the basketball team. And while the record does not clearly lay out how many students that was, it was likely a small portion of the students at the school, and a disturbance that would not in any way affect the entire body of students. So we rest on our written brief for the remainder of our argument. For the aforementioned reasons, we ask this court to reverse the findings of the District Court of Appeal for the 7th District and find Florida Statute 836.15 to be unconstitutional.
Thank you, counsel.
Chief Justice Rowe, honorable justices, may it please the court. My name is Anna Schulman, and today, alongside my co-counsel Lindsey Browner, we represent the petitioner, CBA. Of the two issues presented today, I will present the second issue. The compulsory search of CBA's phone was unreasonable and therefore a violation of her Fourth Amendment rights. The search was a violation of her Fourth Amendment rights for the following three reasons. First, there had been no reasonable suspicion set out to search the phone or the bag. And second, even if you find that there was reasonable suspicion for the bag, probable cause was needed to search the contents of the phone. And third, there were no exigent circumstances necessitating the need to search the contents of the phone, and even less for a private Instagram account within the phone. On page 342 of New Jersey versus TLO, the Supreme Court established that determining the reasonableness of a search involves a determination of whether or not, first, the search was justified at its inception, and second, whether or not the search had been reasonably related to the circumstances that had justified the search in the first place. Now, there had been a photograph that had been handed of petitioner's post. However, there had been no account name within this picture of the post. And therefore, there was no linkable information connecting the post to an account and no information connecting an account to CBA's phone or CBA herself.
But don't school officials, they're operating in a school environment with all sorts of kids, and they're hearing from kids what's going on, and it seems far-fetched that they wouldn't be able to link. There was a picture there, of course, but that they wouldn't be able to link this phone or this person with this post.
Well, yes,
what am I missing? Yeah.
Yes, Justice Osterhaus. Although there is a picture provided of CBA, any other student could have actually posted a picture of CBA with the same caption. That doesn't necessarily mean that CBA herself was the one to post that message. Now, further, even if you do find that there was reasonable suspicion to get to the actual backpack, just because there was a phone inside that backpack doesn't mean that the owner of the phone is the same owner of the backpack. And furthermore, in order to actually search the contents of the phone itself, probable cause would be needed. Now, in page 388 of Riley versus California...
Is that because there was a law enforcement officer there? Why probable cause and not reasonable suspicion?
Your Honor, probable cause would be needed in this case because, as established in Smallwood v. State, which was cited within State v. KC, a cell phone is a trove of personal information unlike any other static object which may be searched. And therefore, in addition to the case of Riley v. California, which establishes that officers must generally secure a warrant before any search of data of a cell phone, this is a much greater intrusion into CBA's personal life, giving access to all sorts of information, because in addition, the search was not just limited to
But this is also a school, right? So you fill out all sorts of forms and give it to the school. They know a whole lot about their students, and they're teaching them and forcing them to sit in class every day and answer questions and whatnot. In the school context, or doesn't the school context change the whole analysis?
Your Honor, while we would concede that only reasonable suspicion would be needed to get to the bag and the phone, it would change to probable cause because of how great an intrusion is. And further, TLO establishes that these same Fourth Amendment protections do apply to students in schools. And therefore, it is the interest to still uphold these Fourth Amendment constitutional guarantees that students, even if they are younger, still do retain.
So is it your position, to make sure I understand your argument, that the probable cause standard is appropriate here because it is a cell phone at issue as opposed to the purse that was at issue in TLO?
Yes, Justice Wright, that is exactly where the distinction would come between TLO and the case at hand.
Well, is there any evidence in the record that the officers, the school officials, did anything more than open up the cell phone, look into its contents to the Instagram account, get the information it needed, and then move on, just like for the purse, looked inside, found the marijuana paraphernalia, and moved on?
Justice Wright, per the record on page 2, paragraph 2, the search was not just limited to the Instagram post. Rather, it was expanded to the entirety of the contents of the phone in order to access the Instagram post. However, this is far too broad because in individual cell phone records, it is this trove of information as cited by State v. KC, which can entail all sorts of records, notes, and other personal information that would make it a higher standard. And further, there were no exigent circumstances because not only did they already have the information needed contained within the post, but also, if there are these other exceptions that respondents may argue that it could have been accessed through a phone or another account, this would not only be making these exceptions not exigent anymore. They would instead become the rule. And so for this case, further, we would turn the court's attention to King versus United States, which says that courts require something more than mere proof that fear of police detection had actually caused the destruction of evidence. There was no other evidence suggesting that this information was in a position to have been deleted, and therefore we rest on the remainder of our written argument on our brief, and for the aforementioned reasons, we ask the court to reverse the findings of the 7th District Court of Appeal and find that the search was unconstitutional.
Thank you, counsel. You may proceed.
Chief Justice Rowe, Honorable Justices, may it please the Court. My name is Pooja Gador, and I, along with my co-counsel, Brian Lee, represent the respondent in this case, the state of Florida. Of the two issues before the court, I will present the first issue, that the application of Florida Statute 836.15 to petitioner's conduct did not violate her right to free speech. We ask this court to affirm the decision of the 7th District Court of Appeal for 3 reasons. 1, the statute is content neutral. 2, even if this court finds that it is not content neutral, but rather is a content-based restriction, then it still survives strict scrutiny. And 3, the statute was constitutional as applied. To start, Florida Statute 836.15 is content neutral. If a statute is aimed at the non-communicative impact, then the law is content neutral, per State v. Conforti on page 353. Content-neutral regulations are subject to the 4-prong O'Brien test, as outlined in Flanagan v. Fulton County.
Can it be content neutral if all it cares about is sort of negative speech, teasing, social exclusion, threat, intimidation, blah, blah, blah? It's interested in speech that discourages or that threatens or is directed at somebody in a negative way. It's not interested in encouraging Hallmark card-oriented things.
Justice Osterhaus, in this case, we're not trying to limit what students can say. We're simply trying to limit the effects of cyberbullying on students. So the first prong of the O'Brien test is that it's within the power of the government. And if I could turn your Honor's attention to page 184 of Miles v. Edgewater, the court noted that the government has the power to regulate matters that involve health, welfare, safety, or the morals of the people. Second, it furthers an important substantial interest. If I could turn your Honor's attention to paragraph 4 on page 4 of the record, the interest in this case was to limit the effects of cyberbullying on students. Third, the governmental
Counsel,
interest.
may I ask you about that question? Where do you find that legislative interest, that is to limit the effects of cyberbullying?
Yes, Your Honor. On paragraph 4 and page 4 of the record, the compelling interest here was to limit the cyberbullying and what it can have on students. Now, while Ms. Browner contends that the interest is to limit phone disruptions in school, while that was an interest, the specific statute in the record is regarding cyberbullying, which actually does cause phone disruptions in school, like in this case.
Because the record, perhaps the record is unclear on this point, but the record says that the legislative intent was to prevent substantial disruption in the classroom. So, I mean,
Yes.
that comes from the record.
Yes, Justice Ray, and we do contend that that is an interest in this case. And the statute narrowly tailors it to that because cyberbullying does cause harmful effects on students. And in this case specifically, these students were going on their phones during class because of the cyberbullying that was occurring. And in that way, by addressing cyberbullying in that case, you're directly furthering that governmental interest.
Why not just ban cell phones in the classroom?
Yes, Chief Justice Ray, that would not be, that could happen. However, the legislature determined that because cyberbullying can have such harmful effects, criminalizing it ensures that these effects will be mitigated in classrooms because cyberbullying can have very harmful effects. For example,
Right, and I'm sorry to interrupt you, but I mean, we concede the effects of cyberbullying can be very severe. Why not take the phones out of the classroom rather than, put a limit on speech?
Your Honor, in this case, the statute would not be putting a limit on speech because it's not saying that students can't say anything on social media. It's just looking at the effects it has. So, for example, while Ms. Browner argues that this is a prior restraint, we're not saying that students can't say anything on social media. We're just looking at the effects it can have on the students. Even if this court finds that it is not a content-based regulation and is a content-based restriction, then it is subject to strict scrutiny, which it survives. In strict scrutiny, the government must show that it has a compelling interest and is narrowly tailored to achieve that interest. As mentioned, the government does have the interest in this case to reduce phone disruptions in school, and doing that through cyberbullying ensures this. Now, the statute is not overly broad
But
to address.
how is that narrowly tailored if the statute says nothing about schools? The statute is much broader than schools, but the intent, what I'm hearing, is school-based.
Yes, Justice Osterhaus. While we are only given part of the statute in the record, that is regarding students and the effects that it has on students. In this case, to address Justice Ray's question for Ms. Browner, this statute is not overbroad because it's not criminalizing all speech, but rather only speech that causes harm in this case. In this case, it would be the speech that the actions that falls under the categories listed in the statute. Meaning individuals are able to engage in free speech so long as it does not meet the criteria as listed in the statute.
So something like teasing, basically, that goes on all day, every day. Even the best of friends, they tease each other, and it's fun. But the linchpin of this is if somebody decides to react in a different way, then it becomes criminal. It is kind of what I'm hearing. So that it's not about the act, it's about how somebody responds.
Justice Osterhaus, we can look at the two parts of the statute to answer this. So the first part of the statute says that it must cause physical or psychological distress, and the second part says that has to happen through teasing, social exclusion, or the other categories listed. So taking that first part, the person must find that it did inflict distress. However, also, it must reasonably fall under those statutes. So for example, if one friend is teasing another, that reasonably wouldn't fall under the statute because there would be no actual harmful effects there as they're just two friends. Further, while Ms. Browner argues that this was unconstitutional as applied, this statute was constitutional as applied, and we could look to the case of Tinker v. Des Moines. In Tinker v. Des Moines, it said that there had to be substantial disruptions in school, which is exactly what happened in this case. Several students walked out of several classes and interrupted the disruption in that school and schools around the county. For the aforementioned reasons, we ask this court to affirm the decision of the 7th District Court of Appeal and find that the application of the Florida statute to petitioner did not violate her right to free speech.
Thank you, counsel.
Chief Justice Rowe, honorable justices, and may it please the court. My name is Brian Lee, and today I will present the second issue, that the warrantless search of petitioner's phone on school grounds did not violate her right to be free from unreasonable searches and seizures. We ask this court to affirm the finding of the 7th District Court of Appeal for the following 3 reasons. First, there's a difference in a student's expectation of privacy in a school. Second, the disruption of the post in a school calls for immediate action from school officials. And third, under the 2-pronged test in TLO, the search was justified in its reasonableness. First, in schools, students have a different expectation of privacy, as ruled in New Jersey v. TLO on page 341. The purpose of a school is to effectively teach and to educate a student. And in New Jersey v. TLO, the court ruled that there's a balance between a student's expectation of privacy as well as the school's equally legitimate interest in maintaining an effective learning environment. And this is completely different from the normal requirement for public authorities, where public authorities only need probable cause. In a school, officials acting in a school environment only need reasonable suspicion. And for the principal in this case, using her common sense, she could reasonably infer that based on the parents' report as well as the report of their fellow peer, that CBA was the one who possibly committed this crime.
Was there any, though, information that the school officials had that it was actually petitioner's account that was posted the offending material?
Yes, Your Honor. Based on the principal's reasonable inference as well as the parents' report of CBA's post, officials could reasonably believe that CBA was linked to this.
Well, I'm sorry, just to be clear, did the parent that provided the screenshot, did that parent make a representation that this came from the petitioner's account?
No, Your Honor, and that's the other purpose of this search, is to determine who exactly this post is linked to link the person to the post and to corroborate the parent's claim and to figure out the nature and extent of this alleged crime.
So they could have searched multiple backpacks, is that, and under that analysis, right? So if they suspected, well, it's one of these 5 people, under your analysis, the school could have searched all 5.
No, Your Honor, as in this case, based upon the facts and the principal's common sense, they believe that both the student pointing out a specific backpack as well as the parent's report would lead them to believe that CBA was the one who committed that crime.
Why would that student's pointing to the backpack be reliable and sufficient for the principal to rely on?
Your Honor, on page 2 of the record, school officials went to talk to the students about the post, and the student was in the gym when the principal was talking about this post, and then afterwards had pointed out the backpack in a locker room to the principal. And further, when CBA went to gym class and left her backpack in the locker room, she gave up her subjective expectation of privacy, and we can't expect officials to avert their eyes from potential criminal activity. Second, the post, which was a clear, widespread disruption in schools, had to be stopped immediately. Now, according to Goss v. Lopez cited in TLO, Justice White wrote that events calling for discipline are frequent occurrences and require immediate, effective action. On page 2 of the record, students walked out of class and caused a disruption in schools, and at this point, the functions of a school could not be properly carried out.
But given the nature of social media, I mean, there's no drawing it back, correct? So the idea that this has to be immediately stopped so that it can be stamped out, I get it if this is an oral thing and someone just continues to yell obscenities or something in the school hallway, hey, let's deal with this and we can bring this to an end. But when you're talking about social media, really, is this about stopping the media from going forth?
Yes, Justice Osterhaus, as the schools is in a unique situation to also prevent cyberbullying, as cyberbullying is a very serious issue in our school. It causes potential self-harm, substance use, or mental health issues. And for every minute that the post is on the internet for, there will be more people that see it, and the effects will be greater, and these effects can possibly spiral out of control.
So why not prosecute all the people who, put hashtag basketball sucks and they made it bigger? Did they engage in cyberbullying?
Your Honor, there's Chief Justice Rowe, there's no specific evidence linking these people to the posts that were made. However, in this case, our goal is to corroborate the parents' claim of the cyberbullying by CBA and to determine the nature and extent of the crime.
Let me ask you a hypothetical then. If hypothetically there were 3 other students who retweeted or, made this Instagram post trend, they were also students, also shared the opinion, would they be subject to the prosecution by the state for cyberbullying?
Yes, Your Honor. Chief Justice Rowe, under the current cyberbullying statute, if there was enough evidence to link them to the post that they made, as well as these effects that caused this significant disruption in school, then it's possible that they would be subject to prosecution under the cyberbullying statute. And further, school officials were justified under the 2-pronged test set forth in New Jersey v. TLO. First, that the search was justified at its inception, and all officials needed to believe that the search would turn up mere evidence of the cyberbullying crime. We concede that there is no account name, as Ms. Schulman would argue. However, Justice Osterhaus's question to my opposing counsel, our goal is to find out exactly who exactly this post is connected to, as hypothetically someone else can make a post of me under my name, but it doesn't necessarily mean that I'm the one who made that post. And our goal is to link the person with the account and the post. And through the parents' report of CBA, as well as the pointing out of the backpack, officials reasonably believed that she was the one who had committed the crime. And under the second prong, the search was logically linked to what the officials were looking for. In this case, they were looking for the disruptive post. And under page 330 of TLO, the court allows officials to determine the nature and extent of this crime. We do concede that there will be some sort of intrusion into a phone. However, in this case, the only way that officials could have found evidence linking CBA to the actual account was through her personal phone. Now, my opposing counsel, Ms. Schulman, might try and bring up other alternatives, such as having CBA log in through an outside computer or, say, subpoenaing Instagram. However, none of these will work as, for example, subpoenaing Instagram will leave the post out on the internet for even longer, and this will cause even more disruption and harm. And the only way to link CBA to the post is to see whether or not she has the login information to the specific post and account. Chief Justice Rowe, I see my time has elapsed. May I briefly conclude?
You may.
We rest on our written brief for the remainder of our argument. And for the aforementioned reasons, we ask this court to affirm the decision of the 7th District Court of Appeal and find that the warrantless search of petitioner's phone on school grounds was constitutional.
Thank you, counsel.
May I proceed, Your Honor?
You may.
May it please the court. In 1969, Justice Fortas said, "Any word spoken that deviates from the views of another may cause a disturbance, but our Constitution says that we must take this risk." Your Honors, both the Florida statute and the warrantless search and seizure of CBA's phone are unconstitutional for 2 main reasons. First, the statute is unconstitutional on its face, and second, there was no probable cause to justify the search of petitioner's phone. First, Your Honor, and as to Justice Osterhaus's question to the respondent, this statute is content-based. However, even if this court does find that the statute is content-neutral, it still fails the 4th prong of the test set forth in U.S. v. O'Brien. This is because of the lack of intent requirement and the lack of restriction on the times and places when phones may be used and when the statute applies, making the statute much larger than necessary in order to further the governmental interest. Additionally, Your Honors, and as to the second issue, State v. Casey on page 954 found that phones are a trove of information, different from any other static object. And Your Honors, without a warrant, this was too intrusive a search. As to Justice Osterhaus's question to the respondents, there were other options, like subpoenaing Instagram for the post, even after it had been deleted. So for the aforementioned reasons, we ask you to reverse the findings of the 7th District Court of Appeal and find both the Florida statute and the search and seizure of the petitioner's phone to be unconstitutional.
Thank you, counsel. Thank you all. This court is adjourned. Hi.
Hello.
Good afternoon and welcome to the Supreme Court of Florida. We have one case on the docket today, CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning, Madam Chief Justice Rowe, Honorable Justices, and may it please the Court. My name is Matthew Rodriguez, and along with my co-counsel, Jake Sang, I have the pleasure of representing the petitioner in this case, who, for the purposes of her privacy as a minor, will be referring to as either CBA or just simply the petitioner, excuse me. And Madam Chief Justice, at this time, we'd like to request 2 minutes for rebuttal.
So noted.
Of the two issues before the Court today, I'll be representing issue one. That is whether the petitioner's state and federal constitutional rights to free speech were violated by the application of the statute in this case, Section 836.15. We'll be asking this Court to overturn the lower court's ruling and remand this case for dismissal for the following two reasons. First, the statute is in and of itself facially unconstitutional, as it is overbroad and fails to survive strict scrutiny. And secondly, the application of the statute to the petitioner's case is a violation of her First Amendment rights. And before I begin, would the Court like a recitation of the facts?
No, counsel?
Yes, Your Honor. Beginning with the facial challenge, the First Amendment's protections are vast, they are broad, and the state is only allowed to regulate free speech with limited circumstance. A statute is facially unconstitutional if it is overbroad pursuant to U.S. v. Williams, the Supreme Court of the United States, and U.S. v. Williams, if it covers a substantial amount of protected speech. And in this case, the statute covers a substantial amount of protected speech insofar as it criminalizes intimidation, criminalizes teasing, criminalizes humiliation pursuant to the statute. I'd like to direct the Court's attention to United States v. Flory. This was a case in the 11th Circuit Court of Federal Appeals in which a defendant made a overbroad challenge to a very similar cyber-stalking statute. And the court in Flory found that the statute in Flory was not overbroad because of key mens rea language in the statute that narrowed the conduct that it applied to. That was language such as intent to kill, injure, harass, or intimidate, language requiring engaging in a course of conduct, which the court in Flory found to be evidencing a continuity of purpose. And the court in Flory doesn't mention this, but I think it's prudent to consider. The statute in the cyberstalking statute in Flory had a qualifier of harm. The statute required that the harm suffered not just be existing, but be substantial pursuant to the statute.
So your problem here isn't as much with the maybe the public or private humiliation, physical violence, or intimidation, but you have big problems with teasing, social exclusion, and other things that are less overtly harmful, physically harmful components to them.
You'd be correct, Justice Osterhaus, and we contend that humiliation is in and of itself encompassing a large swath of protected speech. But it's because the statute encompasses, like you said, a large swath of protected speech from those specific prongs of the statute, as well as the fact that it lacks a mens rea element, is why we contend that the statute is overbroad. Secondly, we contend that the statute is a content-based regulation of speech. I'd like to direct the Court's attention to Fox v. Hamptons and Metro West Condominium Association Incorporated, in which the Court, citing United States v. Cassidy, noted that in most cases where the provision focuses only on the content of the speech and the direct impact that the speech has on the viewers, it is content-based. And in this case, Section 836.15 is doing exactly that. It is regulating bullying, and it is regulating the direct impact that the content of that bullying has, the infliction of physical or psychological distress. And it's for that reason.
Doesn't the term bullying imply there needs to be some kind of intent to harm?
To answer your question, if the term bullying were to imply that, or if this Court were to find that the term bullying would imply that, the statute would be overly vague insofar as the term bullying does not give sufficient notice as to any mens rea. There is no explicit mens rea, as the Court found in Fleury, explicitly stated in the statute that would be sufficient to narrow the conduct that it applies to. That would be our answer to your question, Chief Justice Rowe. As a statute subject to strict scrutiny and a content-based statute, it must survive strict scrutiny and be narrowly tailored towards a compelling government interest. If the government interest be the one reflected in the record that the government advanced the prevention of use of cell phones in the classroom, the statute is certainly not narrowly tailored insofar as nothing in the statute limits the electronic communication used to cell phones. But if the government interest advanced being the prevention of disruption within the classroom, citing to Tinker v. Des Moines Independent Community School District, those broad interests asserted there by the Tinker Court, we'd also contend that the statute is not narrowly tailored for two key reasons. First, the statute does not make a distinction between on- and off-campus speech. The fact that the statute can criminalize speech regardless of whether it occurs on or off campus, or regardless of whether the distress occurs on or off campus, means that the statute is criminalizing a whole category of speech without without regard to whether or not that speech actually does cause a disruption on campus.
I'm glad you raised that. So that distinction, what about the time element? I mean, what if a student posts something over the summer and then someone's distressed in, September when school starts back? Is that a problem with the statute, or yes or no?
Chief Justice Rowe, you're exactly right. That's a major problem with the statute. There are large breaks, even small breaks, but especially, as you point out, large breaks during which students are not on campus. Any distress incurred and suffered by the student would not disrupt the classroom environment, and therefore the statute is not narrowly tailored in that respect. You're exactly correct, Chief Justice Rowe.
Counsel, let me ask you, go back to your argument about that this would criminalize both off-campus speech and on-campus speech. But if the off-campus speech is made through social media being ubiquitous, able to travel into the classroom, even if it's made across the street, why wouldn't that have the same impact on the disruption of the classroom as if the speech were made on campus?
I think you raised a good point, Justice Ray. And to answer that question, I direct the Court's attention to Mahanoy Area School District VBL. Even if there were to be an implication, or even if there were to be distress incurred if there were to be a disruption in the classroom environment due to a bleeding over from the effect of a post on Instagram during off-campus school hours, the analysis in Mahanoy Area School District VBL, the Supreme Court notes that off-campus school hours, the school and the government by proxy has a limited interest, a more diminished interest.
I'm not talking about, just to be clear, I'm not talking about after hours. I'm talking about if the student during school hours was across the street, on the way back from a dentist appointment and made the social media post, and it had the same disruptive effect as the one that was made in the classroom, why would our analysis be any different from a constitutional framework?
To answer your question, time exactly is actually a concern as to whether or not substantial disruption exists. Here, and may I briefly conclude? I see my time has elapsed.
You may.
Thank you. You're exactly right, Justice Ray. The statute should also make a distinction between place as well as time. And it's for those reasons that we find the statute to be unconstitutional, and we ask this Court to reverse the lower court's decision and remand for dismissal.
Thank you, counsel.
Good afternoon, Madam Chief Justice, honorable justices, and may it please the Court. My name is Jake Sang, and today it's my pleasure to represent the petitioner in this case, CBA.
Of the two issues before the court today, I'll be addressing the second, on how the trial court's denial of the petitioner's motion to suppress should be overturned based on her Fourth Amendment rights against unreasonable searches and seizures. We believe that the decision of the trial court should be reversed for three key reasons. Firstly, because the TLO standard did not justify the search. Secondly, because petitioner did not consent to the search being made. And third and finally, that no exigent circumstances justified the warrantless search. The first reason we believe that the decision of the trial court should be overturned is based on the fact that the TLO standard did not justify the search. The case New Jersey versus TLO established a two-pronged test under which school officials can justify the warrantless search of a student's belongings. Essentially what happened in that case was that a teacher observed two students smoking in the bathroom and then reported it to the vice principal. The vice principal then took that report and justified it under reasonable suspicion to search one of the purses of the students, establishing the preceding test after the court upheld that search as reasonable. However, we believe that there are a few key distinctions between this case with CBA circumstances and the case of TLO that make the TLO test inapplicable specifically in this case. The first distinction is the purpose of the search in and of itself. In TLO, the search was for a more school administrative purpose to find the evidence of contraband, in that case specifically the rule-breaking cigarettes in the defendant's purse in New Jersey versus TLO. However, in this case, the purpose of the search being conducted was explicitly for a criminal investigation, and the search was conducted by the school resource officer, who is essentially just a police officer who just so happens to be working in a school. We believe that because it is for a criminal investigatory purpose, the lower standard of reasonable suspicion that the court applied in TLO is not applicable to this case, given that the search was for the purpose of finding evidence in order to implicate the petitioner in criminal conduct and corroborate the criminal accusations against the petitioner.
Wasn't it both? I mean, I would guess that there's school effects to what happened here. I don't know. It's not part of the record. Or at least the potential that that's the direction in which things were headed, but then there was this criminal statute, too, that things happened to go that way.
Your Honor, we believe that even if there will be school effects, we don't think it's reasonable to justify under the standard of reasonable suspicion a search for a corroboration of criminal activity. We believe that the search in TLO was justified under reasonable circumstances, that searching for the contraband, in that case the cigarettes, would further the school's interest in maintaining the learning environment. However, making the accusations against the petitioner in this case and trying to corroborate the criminal charges against the petitioner in this case did not serve the school's interest in maintaining the learning environment, thus making the circumstances distinctive between each of the cases.
So the search was fine for school purposes, but it's not fine for criminal purposes?
Your Honor, we believe that if the search were to be for criminal purposes, then the lower standard of reasonable suspicion, as applied in TLO, should not be able to reasonably justify the search.
Assume we disagree with you. Is there reasonable suspicion present here?
Your Honor, even if the court were to find that the TLO test was entirely applicable to CBA circumstances, we believe that reasonable suspicion was not created, given the evidence that was provided to school officials in this case. Namely, the only evidence that school officials relied on was a partial screenshot from a parent, from a member of the basketball team, that did not even include the name of the account, meaning there was no reasonable belief that the petitioner was actually the one who made that post. In addition, the identification of the backpack, of who the backpack belonged to and the backpack that the school official searched, was made by another member of the basketball team that did not show any other indication of reliability, which is the only identification that the school officials relied on in conducting the search of CBA's belongings.
Well, I mean, school officials generally kind of know have their finger on the pulse of what's going on in the school, and this is a basketball team, so it's not that many people. These two individuals evidently knew each other, at least they tried out together and what have you. Why would that person not be a reliable source?
Your Honor, we still believe that school officials should not be able to justify the search based on the identification made by one person alone. In addition, the fact that that identification was made by a member of the basketball team who is a subject of CBA's post made it so that that identification might have been made impulsively and inaccurately, that school officials would not be able to rely on it in this case. In addition to that, we believe that specifically because this search was of a phone, there are distinctive circumstances that make the TLO test inapplicable. Namely, in the case of Riley versus California, the court held that a phone is a treasure trove of information that is unlike any physical piece of evidence in that it contains more information than any physical piece of evidence ever could. That is why, in the case of Smallwood v. State, that the court ruled that the search incident to arrest exception to the Fourth Amendment, which is a universally and widely accepted exception to any search under the Fourth Amendment, does not apply when that search incident to arrest is of a cell phone, meaning that school officials had to get a warrant in this case, even if the facts of CBA circumstances were upheld by the TLO test. Because the search was specifically for a phone, they needed to get a warrant before conducting that search, given just the amount of information that's contained on that phone.
And the fact that this is a school case doesn't matter. I mean, schools are unique in that they can compel people to sit in a chair for 6 hours a day, right? And we don't have a problem with it. No one else can do that, but schools can.
Yes, Your Honor,
Why aren't the rules separate for phones?
We still believe that given the amount of information that is on a phone, any exception to the Fourth Amendment does not necessarily apply to a search of a phone, and school officials should have gotten a warrant before conducting their search. The second reason we believe that the decision of the trial court should be reversed is based on the fact that the petitioner did not consent to the search being made. The case State v. Thomas established the test of objective reasonableness, or what a typical reasonable person would infer from the exchange between the officer and the suspect in evaluating the scope of a suspect's consent. We believe that this test, applied to CBA circumstances, showed that CBA was not necessarily giving consent or permission to conduct a search when ordered by school officials to unlock her phone. Instead, she was simply not objecting to a much higher authority with her position as a child in a school being ordered by the two most powerful people inside of that school to unlock her phone. We believe that just following that order did not amount to consent or implied consent to a search. It's for all these reasons that we ask this honorable court to reverse the decision of the trial court and deny the motion to suppress. Thank you.
Thank you, counsel.
Madam Chief Justice Rowe, Honorable Justices, good afternoon and may it please the Court. My name is Aditya Sharma, and along with my co-counsel Natisha Makesh, we have the pleasure of representing the respondent in this matter, the state of Florida, on behalf of the Florida School District. In today's proceedings, I will be addressing Issue 1 on whether the application of Florida Statute 83615 to petitioner's conduct violated petitioner's federal and state constitutional right to free speech. For purposes of today's arguments, I will be referring to the petitioner as her abbreviated name, CBA, due to her status as a minor. We ask the Court today to affirm the lower court's decision in denying the motion to dismiss for the following three reasons. First, Florida Statute 836 is constitutional, as the statute was enacted for the purpose and the protection of the general welfare and public safety of students online. Second, the Florida statute is content neutral and survives the intermediate scrutiny test. And finally, CBA's online statements meet the language of Florida Statute 83615. First and foremost, the First Amendment to the Constitution extends and protects the rights to free speech and freedom of expression. However, this does not abridge the right of the state to enact legislation abridging the freedom of speech if it's for the purpose of the protection of the general public, morals, or general welfare of the people itself.
Counsel, where did you derive that particular legislative intent for this statute, that it was designed for the protection of the general public and the safety of the students?
Well, you can see that in the plain language of the statute. And the statute states, cyberbullying is the bullying through use of technology or electronic communication that inflicts physical or psychological distress on one or more students, involving teasing, social exclusion, and other illustrative examples qualifying how this physical or psychological distress can be met.
Counsel, how do we what do we do with the fact that the express legislative intent, at least as reflected in the 7th DCA opinion, was to prevent the disruption of the classroom environment?
And yes, that is one of the legislative intents of the statute, as cited under the case of Tinker versus Des Moines. However, the intent of the statute is to protect students from cyberbullying itself. And that's evident in just the plain language of the statute, as the statute states students and focuses in on the physical and psychological distress, preventing students from receiving that type of harm from cyberbullying online. And this is clear in the case of City of Erie versus PAPS, in which we had a municipal ordinance banning all public nudity. And the Supreme Court of the United States held in that case that the public nudity statute was constitutional as it was enacted for the purpose and the protection of the general public and people from unwanted scenes of nudity and public nudity.
Well, let's talk about the limits on the statute or its reach. Would you concede that if a student were to post something over the weekend in the privacy of their home about the basketball team, same facts, same language, same reaction, would the state prosecute?
Yes, Your Honor, they definitely would. And that's because the purpose of the statute is for the purpose of preventing cyberbullying and also for a disruption in the classroom.
Okay, let me ask you another hypothetical. What if you posted it, the first day of summer, and people read it in September when school started? Same exact speech, same exact reaction. Prosecutable?
Yes, Your Honor. Secondly, a statute restricting free speech is either content neutral or content based. And a content neutral statute restricts conduct without specific reference to the content of the speech involved, while a content based statute restricts the type of speech and the specific speech. Pursuant to the case of Fulton County versus, Flanagan Enters versus Fulton County. Due to the statute's language of not restricting posting, but merely restricting the type of harm, this statute would be deemed to be content neutral. And we can see this distinction clear as day in the case of the United States v. Fleury, in which we had a cyber stalking code that stated engages in conduct with intent to kill, injure, harass, or intimidate. And this statute by the court was deemed to be content-based due to its language specifically outlining what you can't say and specifically outlining the content of the speech involved. However,
but the language of the statute here, and I do appreciate your appreciation and stress on the text of the statute, but it talks in terms of criminalizing teasing, social exclusion, threat, intimidation, and the type of language that is of a certain ilk, a certain type of language that is discouraging or threatening or intimidating. It's not outlawing, hey, good job, Hallmark card type language.
And you're completely correct, Your Honor. And the purpose of those illustrative examples in this case is to qualify how physical or psychological distress can be met. It can either be one of those examples, multiple examples, or, just one or multiple of those examples. And again, pointing the court back to the United States v. Fleury, in Fleury it gave criminal offenses as examples, not illustrative examples, criminal offenses that are not protected free speech under the First Amendment. And my friend, the petitioner, Mr. Rodriguez, pointed out to the court the intent element in United States v. Fleury. However, that is irrelevant to today's case because in the state of Florida, there are two types of criminal statutes. Statutes with an intent element and statutes without an intent element. And this is just an example of a statute without this intent element. Furthermore, considering the statute is content neutral, it would be deemed to be under and fall under the test of intermediate scrutiny, which states that the government must show a substantially related to an important government interest. And the Florida statute advances a narrowly tailored important government interest, and exactly as Justice Rowe pointed out, because the Supreme Court of the United States 50 years ago in the case Tinker v. Des Moines stated that a school has a heightened interest in regulating speech that causes disruption to the school and the school's learning activity, as well as making sure that the speech doesn't invade another student's constitutional rights.
But in Tinker, that dealt with a disciplinary rule. That did not deal with a criminal statute. So does the Tinker analysis really even apply here?
Yes, Your Honor. The Tinker analysis will apply here for the legislative intent and for the purpose of the enactment of this statute and relating it to the type of harm. And it also is important to this case to show why the school has a heightened interest in regulating this type of speech and petitioner's conduct in this case. As on page 2 of the record, it cites the fact that this substantial disruption occurred. And furthermore, that every student in the state of Florida has a right to education. And this was abridged because of CBA's rights and CBA statements online against these students. And furthermore, the petitioner in this case pointed to the case of Mahanoy versus BL, but neglected to put out the most important part of this case, and that was Justice Breyer's opinion in that case, which he cited in favor of the student in that case, but for the following 3 reasons. First, petitioner's statements were made off campus, it caused no serious substantial disruption to the school's learning activity, and the school went too far in restricting her right to free speech. Seeing my time has elapsed, I would ask for a brief moment to conclude.
May.
And in the case presented before the court today, all 3 reasons that Justice Breyer had outlined in his opinion are reversed. The statements were made on campus. It caused a serious substantial disruption to the school's learning activity, and the school did not go too far in restricting her right to free speech. And therefore, the school holds a heightened interest in regulating petitioner's conduct in this case. And for those reasons, we respectfully ask this court to affirm the lower court's decision in denying the motion to dismiss. Thank you, Your Honor.
Counsel.
Madam Chief Justice Rowe, Honorable Justices, and may it please the Court. My name is Adisha Makesh, and of the two issues presented before this Court, I'll be addressing Issue 2, which is whether the warrantless search of petitioner's phone on school property violated her Fourth Amendment right to be free from unreasonable search and seizure. This Honorable Court should affirm the ruling of the lower court denying petitioner's motion to suppress for the following two reasons. First, conducting warrantless search of petitioner's phone was constitutional under the two-pronged reasonable search test set forth in New Jersey v. TLO. And second, school officials met both of the exceptions to the warrant requirement under the Fourth Amendment. Firstly, according to New Jersey v. TLO, school officials do not need to obtain a warrant to search students' possessions as long as the search is considered reasonable. To define the standard of reasonableness, TLO cites to Camaro v. Municipal Court in that a search must balance the need to which the search is required against the invasion in which the search entails. The U.S. Supreme Court established two prongs to determine legality of a warrantless search, which is as follows. First, whether the search is considered justified at its inception. And second, whether the search is reasonably related in scope to circumstances which justify the interference in the first place.
Counsel, respond to petitioner's argument that perhaps the test in TLO is not appropriate here, because here the search was made for a criminal investigatory purpose and not for the purpose of determining whether or not the student had violated the no smoking rule in school, and that really probable cause would be more appropriate.
Yes, Justice Ray. To respond to petitioner's argument, petitioner claims that a school resource officer conducted the search. However, page 2 of the record reflects that a school resource officer conducted the search in accordance with a school official, the principal. It was the school official who directed the search in the first place. Thus, the TLO standard of reasonable suspicion does still apply due to the fact that it was a school official who provided the basis to conduct the search.
Even so, I mean, Riley instructs us that the search of a cell phone, that there needs to be a great care taken, and it's a much higher standard. And did the state made its burden here to show that it was necessary to search this particular cell phone to discover information about this suspected crime?
Yes, Your Honor, and for two reasons. Under Riley, it states that a warrantless search of a cell phone is not allowed incident to arrest. However, there are some exceptions to that under urgency and compelling government interest. It's also important to emphasize the difference between Riley versus California to the instant case, in that the evidence procured in Riley versus California was not the main evidence. However, in the instant case, the evidence for the cyberbullying that petitioner committed is directly found in the phone. It is the primary source of evidence.
Actually, is it found in the phone, or is that information in the cloud? I mean, where is the information stored?
Your Honor, it's found in her private Instagram account.
Right, and so is that on the phone, or is that in a cloud-based application? And does that matter?
Your Honor, that wouldn't matter, because although it's online in all ways, it's still, the phone is the direct and most primary source of way to find this post and to visually confirm this post and see it at its entirety. To address the first prong of the TLO test, to determine whether a search is considered justified at its inception, reasonable suspicion must be present, and the evidence of the search must suggest that the student has violated the law or the rules of the school. In the instant case, school officials possessed proper reasonable suspicion that petitioner engaged in cyberbullying because the post included a the post included a photo of herself, as well as the fact that a parent brought up the concerns that the post violated cyberbullying statute 836.15. Additionally, petitioner claims that it was a current basketball member who pointed out the backpack of petitioners. However, the record reflects that it was a former basketball member, not a current one. Thus, it provides more reasonable suspicion against petitioner.
But did that basketball player in any way connect the post to the petitioner, or did she just connect a backpack to the petitioner?
Well, Justice, it says in the record on page 2 that while school officials were talking to school students in the gymnasium about the post and the contents of the post, that is when the former basketball member pointed out specifically CBA's backpack and claimed it was continuously vibrating. To address the second prong on whether a search is considered reasonably related in scope, the search must be logically linked to what school officials were trying to find. It makes sense that school officials searched the phone due to the fact that the cyberbullying post, the post flag for cyberbullying, was found online. In addition, school officials had to look at a fair depiction of this evidence rather than rely on a partial screenshot of the post from the parent. They needed visual confirmation that this post to look at all of the contents in its entirety. Thus, both prongs are met for the TLO test. However, in the event that this court does not find that the TLO test applies or the TLO test is not met, then this respondent would like to point this honorable court to the 2 exceptions to the warrant requirement under the Fourth Amendment, including consent and exigent circumstances. Petitioner claims that CBA did not consent to the post. However, citing State versus Aponte from State versus Thomas, Aponte states that providing no nonverbal or verbal limitation or attempt of limitation amounts to general consent. In the instant case, petitioner did not say no.
Is this the kind of consent where you sort of have a gun to your head? Because it seems that school officials here, there's the criminal route, and then there's also they're a school, and they could suspend her, they could expel her, what have you. There are 2 regimes hanging over this CBA's head, the minor's head, which seems pretty compelling. Like, we would like you to put your code in the phone. You know, is there really a choice?
Of course, Justice. Respondent would have to respectfully disagree in the matter of choice, in that CBA could have said no. Although she was told to unlock her phone, she could have said no or set any type of limitations as to what they could search. It does not reflect in the record that CBA was anyway pressured or felt intimidated by these school officials.
But also that she wasn't asked or informed that she had that option.
Yes, Justice, she was not informed. However, she did not set any limitations as to what they could search. And the objective reasonable standard set forth in State versus Thomas states that a typical reasonable person would understand the interaction between the suspect and law enforcement. I see that my time has expired. May I have a brief moment to conclude, Chief Justice?
You may.
And through this reasonable standard, we can see that CBA, although a minor, she's 16 years old. She's used her phone. She could reasonably believe that when asked to unlock her phone, that a search would be conducted. Thus, it is for these reasons that respondent respectfully requests this honorable court to affirm the lower court's decision. Thank you.
Thank you, counsel.
May it please the court, the respondent contends that the statute in the incident case is content neutral. However, I point the court's attention back to Fox, in which just because the statute regulates effects does not necessarily mean that the statute is on its face content neutral. The court in Fox determined that just because a content regulates effects does not mean that it is content neutral. It can regulate the content of the speech and the direct impact of the speech, which is what we see in the incident case with Section 836.15. Secondly, I think the respondent effectively concedes the largest swath of the petitioner's argument in stating that the statute would in fact criminalize cyberbullying that occurred and inflicted distress on a student on the first day of summer. The fact that the respondent concedes this very clearly implicates the fact that the statute is not narrowly tailored towards that compelling government interest of preventing disruption, because a student has now been distressed on a day that is so far removed from school activity, so far removed from that compelling government interest of preventing disruption, that the statute cannot possibly be narrowly tailored, and the statute is very evidently overbroad. Now, with respect to the Fourth Amendment issue, the respondent contends that because the school resource officer was acting under the direction of the school principal, the TLO case still applies. However, a search was still being performed for the purpose of a criminal investigation by a law enforcement officer, with the presence of a law enforcement officer coercing consent from the petitioner. It is very clear to see that the TLO does not apply in this case because there was a school resource officer. And finally, with regards to exigency, the respondent is effectively asking this court to create a blanket exigency exception whenever anything is posted on Instagram and whenever there is evidence of a crime on social media. And the petitioner would very firmly contend this. To conclude the Fourth Amendment issue, I think it's prudent to look at Chief Justice Roberts' opinion in Riley v. California, in which Chief Justice Roberts makes it very clear. When in doubt, get a warrant. And finally, to conclude the First Amendment issue, I would like to quote something from JJM, but it is also a serious matter when the government, as opposed to a school, steps in and decides to charge anyone, let alone a juvenile, with a crime, as opposed to a school's regulation. Thank you.
Thank you, counsel. Thank you all. This court will adjourn. Good afternoon. Welcome to the Supreme Court of Florida. We have one case on the docket this afternoon, CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Good afternoon, Chief Justice Rowe, honorable justices, and may it please the court. My name is Danae Warrior, counsel for the petitioner, CBA, and today I will discuss the first issue, that Section 836.15 violated the petitioner's, the application of Section 836.15 violated the petitioner's federal and state constitutional rights to free speech. This court should reverse the ruling of the Seventh Circuit District Court of Appeal for the following two reasons. One, the statute fails to survive strict scrutiny, the appropriate standard for a content-based restriction of speech. And two, petitioner CBA's conduct was not cyberbullying, and the statute was applied incorrectly to her conduct. Now, it's a content-based restriction of speech as it seeks to specifically target what is considered to be cyberbullying under the Act, which is inherently tied to the content and nature of the speech. The section does not prohibit all types of speech from being spoken in school during hours by student, rather only what is considered cyberbullying, thus constituting a content-based restriction of speech. Now, since it is a content-based restriction of speech, it falls under strict judicial scrutiny, and that composes of two prongs. One, that there must be a compelling governmental interest, as stated in Miles of City versus City of Edgewater Police Department. And two, it is narrowly tailored by employing the least restrictive means.
What is the compelling interest here that is alleged by the state?
Based on the legislative intent found on page 3, paragraph 4, the legislative intent is to prohibit the use of cell phones that have been found to become disruptive to the classroom environment.
Does the statute advance that interest? I mean, does the application of the statute here advance that interest?
No, Your Honor. We contend first that Section 836.15 does not advance the interest of removing cell phones that have become disruptive to the school environment. Rather, it prohibits cyberbullying, which through any form of technology or communications, not merely just cell phones, and it focuses on the idea of cyberbullying, therefore does not achieve the goal of removing the use of cell phones from the classrooms. Now, if the court does not find the compelling governmental interest to be the removal of cell phones from the classroom environment, and rather finds that it is based on the growing issue of cyberbullying and to combat such issues, it is still void under the doctrine of overbreadth.
Counsel, going back to your earlier point, isn't cyberbullying or can't cyberbullying amount to a substantial disruption of a classroom environment, not only for the person that's being, personally targeted by the bullying, but on a broader scale, especially an Instagram post like this that went viral?
Your Honor, the petitioner contends that the legislative intent was to prohibit cell phones that have become disruptive to the classroom environment, not disruptions to the classroom environment as a whole. However, if this court does...
Well, but here, I mean, the vehicle through which this was disseminated was cell phones, right? I mean, it's not just the static cell phone in itself that's disruptive. It's the messages being conveyed, correct?
Yes, Your Honor. And however, the section actually prohibits any type of technology or communications, not necessarily limited to cell phones, which was the legislative intent of the Act. And in addition to this, if the court does not find that it is that the governmental interest is to prevent cell phone usage, rather it's to combat cyberbullying, it is still unconstitutional under the void for overbreadth doctrine. In the case of Broderick v. Oklahoma, cited on page 357 of State v. Conforti, the court held that where conduct and not merely speech is involved, the overbreadth of a statute must not only be real, but substantial as well, judged in relation to the statute's plainly legitimate sweep.
In what specific ways is this statute overbroad?
Yes, Your Honor. Section 836.15 falls under the void for overbreadth doctrine, as the regulation can sweep too broadly and prohibit speech that is both protected and non-protected speech. Students in this case will have to make a guess on whether what they are saying is protected under this cyberbullying statute or is in violation of the cyberbullying statute.
Could you give an example of speech that would be protected and not punishable under the statute, that could be swept in, or shouldn't be punishable?
Yes, Your Honor. For example, if a student were to say, the basketball team sucks, or I hate the basketball team, and admitted to it, so there's no issue, Fourth Amendment issue, merely focusing on the First Amendment. However, if there was no actual disruption, the demonstrated effect hasn't been realized, yet the school under Tinker v. Des Moines went to and arrested the student because they reasonably forecasted that there would be a material and substantive disruption. That student is now arrested without having any impact on anyone else, just because of that forecast. And that student would not know, based on their intent or whatever, that their statement would be prohibited. They would still have to make that guess.
But isn't there kind of an implied intent for, at least for bullying? Do people bully for the purposes of something other than to, create ill will or hatred or demoralization of the intended victim?
No, Your Honor, the petitioner does not dispute the fact that bullying has a specific intent. Rather, that objectively viewed by school officials, there may be a different interpretation on what constitutes bullying and whether or not petitioner's conduct was cyberbullying. And as such, they also found that the petitioner's conduct was cyberbullying. However, this was incorrect. The entire issue took place within 1 day, and it was a single-day disruption, not amounting to the material and substantial disruption required under Tinker to meet this interest. Furthermore, it does not specifically target high school or list the names. And we rest on a written brief for the remainder of the argument, and we ask the court to reverse the lower court's ruling and find 836.15 to be unconstitutional. Thank you.
Thank you, counsel.
Good afternoon, Chief Justice Rowe, honorable justices, and may it please the court. My name is Daniel Bednar, counsel for the petitioner, CBA, and today I will argue the second issue, that the warrantless search of petitioner's cell phone on school property violated her constitutional right to be free from unreasonable searches and seizures. This court should reverse the ruling of the 7th District Court of Appeal for the following 3 reasons. 1, there was not sufficient probable cause to justify a search of petitioner's cell phone. 2, the search was excessively intrusive as there were other means available of obtaining the necessary evidence. And 3, there were no exigent circumstances that would justify a warrantless search of the phone. Your Honors, we concede that the case of New Jersey v. TLO reduces the standard for searching a static object from probable cause to reasonable suspicion. However, the court on page 953 of State v. Casey said a cell phone is different from other objects which might be subject to a search. The Supreme Court in Riley v. California ruled cellular phones place vast quantities of personal information quite literally in the hands of individuals. Accordingly, the court has ruled that there must be a higher heightened expectation of privacy when dealing with password-protected cell phones, and more specifically to this case, in addition, a password-protected social media account.
Should that apply in a school? Because a school has all sorts of information about its students. You got to fill out all sorts of forms to be in the school. You're there 6 hours a day, forced to give answers and to interact with the curriculum and whatnot, and it seems like schools just have that kind of personal information on students. It's just part of how they operate.
Yes, Your Honor. Well, schools might have some of the personal information that you just described on their students by means of their authority over their students. That does not exempt them from the requirement under the Fourth Amendment that they do not conduct unreasonable searches and seizures. And accordingly, the higher standard of probable cause for a cell phone is more suitable to be applied to today's case.
But you've cited Riley, and I mean, you certainly acknowledge that Riley does allow searches of cell phones in some circumstances when there's an exigent circumstance. The state has argued that the circumstances here were exigent, that your client would have sought to delete the files, making it impossible for them to connect her to the crime.
Yes, Your Honor. As to the case of exigency, there was no risk of imminent deletion of evidence. Once the cell phone was seized with the petitioner inside the school principal's office, with the cell phone no longer in petitioner's possession, at that point, school officials could have sought to obtain a warrant. In the case of Riley, citing Missouri v. McNeely, the court stated that recent technological advances have made the process of obtaining a warrant itself more efficient. And the court proceeded to describe a jurisdiction where police officers can email warrant requests to judges' iPads and have a response back in as little as 15 minutes.
Well, under what authority could the school hold on to the cell phone while the school went through the process of trying to obtain a warrant?
Yes, Your Honor. At that point, the cell phone had already been seized by school officials. So accordingly, the petitioner would not have had access to the cell phone at that point in time.
Right, but my question is, under what authority could the school hold on to that cell phone while the school officials attempted to get warrant for the probable cause?
Yes, Your Honor. Precisely, that goes to our first point, that probable cause did not exist in this case to seize and to search the cell phone. The totality...
I'm sorry, let me go back again to my question. Under what authority could the school hold on to a phone that it had seized from a locker if the student said, "Can I have my phone back?"
Your Honor, under the TLO standard, they would simply need reasonable suspicion at that point to seize the phone and the backpack that contained the phone. However, to search through the contents of the phone, because of the data and privacy concerns regarding a cellular phone, the standard to search the phone would then be probable cause. However, probable cause did not exist in this case, as the totality of the circumstances were based on hearsay information that could not reliably establish any link between the petitioner and the social media post. On page 2 of the record, we learned that the probable cause was based upon two facts: a screenshot of the post and a phone buzzing in the petitioner's backpack. As to the screenshot of the post, this did not include an account name, which did not present a sufficient indicia of reliability that would conclude that there is a link between the petitioner and the post itself.
How about when you put it all together? The parent gave information, the student who's there says that's the backpack, the backpack is buzzing, the phone is blowing up, evidently because there's lots of hits on this particular
Yes, Your Honor.
Yeah.
As to the cell phone buzzing inside the backpack, that also would not satisfy the probable cause nor a reasonable suspicion standard. Those cellular phone dings could have come from any number of unrelated notifications from any number of apps, including iMessages, Snapchat, or other Instagram things. That does not establish a link that the petitioner actually posted the post that is in contention today. Second, prong number 2 of New Jersey v. TLO requires that the search not be excessively intrusive in light of the nature of the infraction. The nature of an online post certainly means that there are other methods of obtaining the necessary evidence, such as asking the petitioner to log in on a public computer, perhaps the principal's computer, in order to establish that link rather than searching through the entire contents of the cell phone. And for the aforementioned reasons, we respectfully ask that this court reverse the ruling of the 7th District Court of Appeal and find that petitioner's constitutional rights were violated.
Thank you, counsel. You may proceed.
May it please the court, your honors, and opposing counsel. My name is Alexander Santiago Jess, and alongside my co-counsel, Gabriel Garcia, we represent the respondent in this case, the state, against the petitioner, CBA. This case today is about bullying, the bullying that CBA engaged in August of 2021. Around this date, CBA got news that she did not make her basketball team. This is when she took to Instagram and made an online post which said, screw this high school and this high school's basketball team. The team sucks, and the players on the team also suck. This post made multiple students become affected by it. Students left their classes, looked at their phones, and some were even outraged enough to create a hashtag online called #BasketballSucks.
It seems to me that the state is trying to prosecute speech that students and parents maybe even regularly shout from the stands on the basketball court. Why should it be different when they put it in social media?
Your Honor, it would be different because this furthers the government interest of the government, and that being education. Because phone usage lately has been taking up too much time in the classroom, and so the government has passed 836.15, a statute that reads, cyberbullying is bullying through the use of technology or electronic communication which inflicts physical or psychological distress upon one or more students.
But the reach of this statute is not limited to a student typing in the classroom and posting in the classroom. The student could do it after hours or even during the summer break, as long as the other students reacted. Isn't that right?
Your Honor, that would be the case, but in this case in particular, in CBA versus the state of Florida, that's not in appliance because CBA was in school hours when she made her post. In addition, CBA's post is a content-neutral statute. Well, cyberbullying 836.15 is a content-neutral statute. This is because for a content-neutral statute to be defined as one, it must regulate time, place, and manner, whilst a content-based statute must regulate the expression and ideas contained within the speech. In this case, we're talking about a content-neutral statute because, as you can read, cyberbullying is bullying through the use of technology or electronic communication, which inflicts physical or psychological distress upon one or more students. Specifically, this statute targets technology communication that inflicts students. This would clearly be the manner in which the speech is said in.
Yeah, but it's got to be certain types of speech, correct? It's got to be related to or involve teasing, social exclusion, threat, intimidation, humiliation, physical violence. It's not talking about a happy speech. It's talking about speech that's directed to hurt somebody.
Yes, Your Honor, and those different factors would constitute for what is defined as bullying in this case. So yes,
That's content meaningful, isn't it? Is it not?
But at the same time, it is regulating the content manner, which is that it has to be directed towards students. If this speech was said in the same way, but instead of it saying, screw this high school and this high school's basketball team, instead if it said, screw the Lakers, this would not be cyberbullying because the Lakers are clearly not a high school body. They're not students. So that would be the difference in this case, Your Honor.
Would it not possibly cover happy speech? So let's say, a member of the basketball team posts a picture of a party and everybody's included except for one person. And everybody posts and it's very clear that that one person has been excluded. And they feel bad and they've been psychologically harmed. Is that not cyberbullying?
It would not be cyberbullying, Your Honor, because this would not be the intent of the post. The post is simply to just post a party in this scenario, not to specifically exclude this particular person.
What if the intent were to exclude that person? Notice that Bob's not here today and everyone else is in the post?
Your Honor, then it would constitute for cyberbullying.
Okay.
And additionally, for content-neutral law to be constitutional, which in this case it is, it must pass minor strict scrutiny. And this is defined by this court must weigh that the value of freedom of expression is more relevant or is less relevant than the government's interest in regulating the speech. In this case, the government's interest is education, which is the whole reason for why this law was passed. The interest in education was passed so that the government's interest in regulation is education because if CBA had not posted this during school hours, then it would not constitute for bullying or for cyberbullying specifically because it would not inflict students to walk out of their classes and look at their phones, etc. And we argue that it does pass minor strict scrutiny because CBA is not adding anything of positivity into the world. There's no substance in her speech. This speech simply says, screw this high school sucks, the basketball team sucks, and the players on the team also suck. All she created was a negative environment in which students were outraged, students were prompted to walk out of class, and students even left the basketball team after they had a newfound lack of confidence.
Isn't that the nature of a jury question? Because even sometimes you say you suck, sort of complimenting somebody for what they just accomplished. They just hit a half-court shot. You suck. Like way to go.
I guess in that scenario, Your Honor, it would be the case. But in this specific circumstance, CBA is clearly defining that, or she's clearly saying that the basketball team sucks in a negative manner and is not being offered in a positive manner.
So, counsel, what is the compelling state interest at issue here?
Education, Your Honor.
Just education standing alone, or point me to the record where you're getting that, where you're gleaning that as the legislative intent? Was it relating to education in the sense of trying to prevent a material disruption of the classroom environment?
Yes, Your Honor. In the District Court of Appeals decision, it states that this law was passed as a means to regulate how often students use their phones. This is where I derived this from.
Right. Okay, perfect. So how does the conduct here rise to that level? So even under the Tinker analysis, there were some students that walked out of class, but wasn't that limited in time and scope? I mean, really, did this amount to a substantial disruption of the classroom environment?
Yes, Your Honor. As many of these posts on the hashtag basketball sucks, not only were a couple, but hundreds of posts made hundreds of views, which prompted many students and many high school basketball team members to leave their classes, and this would amount to that substantial interest which we are discussing. For those reasons, we argue that the statute itself is constitutional, as it is a content-based statute, or is a content-neutral statute that does pass minor strict scrutiny, and CBA was in clear violation of it. Thank you for your time, and now my co-counsel will argue the Fourth Amendment issue.
Thank you, counsel.
May it please the Court, Your Honors. My name is Gabriel Garcia, and I'll be addressing the second issue of this case of the Fourth Amendment. As you've heard from my co-counsel, this case is about bullying, the cyberbullying by CBA. Now, opposing counsel states that the Fourth Amendment right violated CBA's, was violated. However, this is not the case. This is not the case, as I'll be arguing 3 points as why this is not the case. My first one is that the search itself was reasonable. Second is that the suspicion of the search was reasonable. And that third is that the exigent need to search CBA's bag was also reasonable to suspect. Regarding my first point, pursuant to New Jersey v. TLO, it needs 2 requirements to search a student's belongings without a warrant. These 2 requirements are criminal activity, suspicion of criminal activity, and that the search needs to be logically linked. To my first requirement, as stated by my co-counsel, the statute is a content-based law. Therefore, it meets the requirement of a criminal activity. So when the principal looked at the post made by CBA, the principal saw a criminal activity happening, or that had already been posted.
How would the principal know that? Wouldn't he need to know CBA's intent in posting?
Well, the intent in the words are, this high school sucks, the high school basketball team sucks, and the players on the team suck.
But if a coach says that and is trying to motivate the team to do better, that's okay, right?
Yes, Your Honor.
The same words.
Yes, Your Honor. However, CBA is not a coach. She is a failed tryout of the basketball team. She did not make it. Therefore, the grounds of which a coach saying something would not be the same as CBA saying something, because she is on a similar level of respect as every student on the team and is talking up towards the high school and basketball team itself.
Counsel, I'm wondering if the TLO reasonable suspicion standard is really appropriate here, because in TLO, the search was made pursuant to an administrative rule of the school. There was no smoking allowed, and we're going to see if you've got cigarettes in your purse. Here, the search is being made for a criminal investigatory purpose. So shouldn't the standard really be probable cause?
No, Your Honor, it shouldn't be probable cause because of the fact that, as my co-counsel stated, there was a statute. This statute was made to regulate usage of phone in class. Therefore, the prosecution of this action is rightful under TLO because of the actions, because of the label that is placed on by the statute 836.15.
So your position is it makes no difference whether we're talking about a criminal statute or just what's at stake is a detention or something like that, that the same standard applies across the board?
No, Your Honor, that is not my stance because we believe that there is that it is a criminal activity, and therefore it's nothing like getting a detention or having someone called upon to bring down to the office to be talked to. For my second point, Your Honors, of the reasonableness of the search itself, I would like to refer your attention to Riley v. California, where it states that a warrantless search and seizure is okay if the prevention of destruction of evidence is exigent. The prevention of destruction of evidence is exigent because of the new advances in the technology nowadays. People can change the way something looks by going on to a application and coloring something out or deleting something and retyping something in. Therefore, the hashtag basketball sucks is not a valid place to get evidence or knowledgeable resources of the post that CBA posted because of the fact that it could not be the true doctrine of the post that CBA had made. As well as my opposing counsel states that there was a risk, there's a lack of account name. However, it doesn't need the account name because the post has CBA's likeness in the post itself. And therefore, you can garner from that visual that CBA is the one that is making the post or is about the post. As well as to my to the second point of TLO, I would like to go back to my second point of TLO about logically linked. The opposing counsel states that it is hearsay. However, it was made by a peer of CBA, which has likely spent a lot of the school year with CBA, therefore knowing what CBA's bag is like and what CBA's methods are like because they spent so much time together as students, as peers. To my third point, Your Honors, of the consent, CBA was called down to a locker phone, and this is not unreasonable, because pursuant to State versus Thomas, in the dissent it says that the scope of suspect's consent is objective, which means that the exchange between two people, if a reasonable person were to observe it, it would be the reasonableness of the exchange.
And I'm glad you brought that up. So, you know, a high school student can't consent to taking aspirin at school, but if the principal and a law enforcement officer stand in front of them and say, unlock your phone, not even asking, but instructing, that's enough to find consent?
Well, Your Honor, this is enough to find consent because the high school student knows that their parent can help them. They should always rely on their parent if they are unsure about a decision. She was obviously sure about the decision because she didn't ask or hesitate to unlock her phone. She unlocked her phone and didn't ask for a parent or anything of the kind. This is why this did not violate her Fourth Amendment. Thank you, Your Honors.
Thank you, counsel.
May it please the court. Your Honors, the Supreme Court in both Tinker v. Des Moines and New Jersey versus TLO have repeatedly held that students do not lose their First or their Fourth Amendment constitutional rights by mere fact that they are a student of a school. With regards to the first issue, it is not time, place, or manner restrictions, as it regulates what speech falls into the category of cyberbullying. It clearly prohibits what students say, even if it occurs during school hours. Also, the compelling governmental interest is to prevent phone-caused disruptions, thus prohibiting cyberbullying through any technological means. With regards to the second issue, even if this court were to find that probable cause is not the standard and that the case of New Jersey v. TLO is controlling, there is no reasonable suspicion to conduct the search. While Respondent contends that the photo of CBA could have been enough to satisfy the reasonable suspicion requirement, that photo could have been of anybody. Thus, it does not present any sufficient reliability that would link the petitioner to the post itself. Second, the second prong of New Jersey v. TLO requires that the search not be excessively intrusive in light of the nature of the infraction. And the greater expectation of privacy, as outlined by Riley, requires officials to seek out these alternative methods. One of these methods would have been asking any of the 523 other followers of the account to open up CBA's Instagram account. And if upon doing that, school officials saw that the post in question was on that account, then a sufficient link would have been established. Finally, Your Honors, there was no consent in today's case. Petitioner was in the presence of authority figures, the school resource officer and the principal, and the mere presence of these figures would indicate coercion. For the aforementioned reasons, we ask that this court reverse the ruling of the 7th District Court of Appeal.
Thank you, counsel. Thank you all. This court will adjourn. Good afternoon. Welcome to the Supreme Court of Florida. Our 10th and final case on the docket today is CBA versus State of Florida. Counsel, when you're ready, you may proceed.
Chief Chief Justice Rowe, Honorable Justices, and may it please the Court. My name is Sophia Masnikoff, and along with my co-counsel, Olivia Robbins, today we represent the petitioner in this case, CBA. Of the two issues before the Court, I will be presenting the first issue, that the application of Florida Statute Section 836.15 violated petitioner's constitutional rights to free speech. Would the Court like a brief summary of the facts?
I think we're familiar with the facts.
There are two reasons this Court should reverse the judgment of the 7th District Court of Appeal. First, the Florida Statute Section 836.15 does not survive strict scrutiny. And second, the statute is unconstitutional as applied. The statute is a content-based speech restriction and therefore must survive strict scrutiny in order to be constitutional based on Miles v. City of Edgewater Police Department, which states, content-based speech restrictions will not survive strict scrutiny unless the government can show that the regulation promotes a compelling government interest and that it uses the least restrictive means to do so. However, the statute in this case is not narrowly tailored to promote
What makes it content based?
Because in this case the statute is focused on limiting the speech itself, the message of the bullying, it's not focused on the reaction to the bullying, therefore it's content-based in this case. So this statute is not narrowly tailored to either government interest. First, the government interest of punishing students for using their cell phones as disruptions in schools, and second, the government interest of protecting individuals from cyberbullying. And first, the statute makes no mention of either schools or phones, so therefore it's not narrowly tailored to that government interest. And further, petitioner's post was not narrowly tailored and was not directed towards any one individual and was made as a general statement about the totality of the school and the basketball team as a whole. Further, in Tinker v. Des Moines, the court held that students do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. The court held that fear of disturbance is not enough to limit the right to free speech. In this case, although there was some disturbance with students leaving their classes, it's not a substantial enough disturbance for the government to limit the fundamental right of free speech in this case. Just because it may be a distraction in the classroom, it's not enough.
Counsel on that? I'm sorry, go ahead. Isn't a group of students storming out of a class, isn't that distracting? Isn't that disruptive to the teaching environment?
Yes, Your Honor. However, in this case, that disruption did not affect the entire school, and therefore it's not substantial enough for the school to regulate their speech and for the government to regulate their speech.
So disruption in 1 or 2 or 3 or 4 classes isn't enough. It needs to be the whole school before the statute can kick in.
Yes, Your Honor. However, in Mahanoy area, school district VBL, that disruption was limited to like 5 to 10 minutes and over multiple days, and I still said that that was not enough for the government to limit their speech. So in this case today, their government interest was only 1 day, and it was only a couple of students leaving class, and therefore it's not enough for them to limit their speech. Further, the statute is unconstitutional as applied. In State v. Conforti, the court said that they will strike down a content-based regulation as unconstitutional unless the government can show that the message being suppressed poses a clear and present danger. However, in this case, although there was some disturbance, there was no threats or acts of violence that could constitute a clear and present danger. Therefore, the school officials did not have a right to regulate their free speech based on a clear and present danger test.
So you're saying that if the statute is fine if it involves a threat or intimidation or physical violence-oriented things, but the statute has problems if it involves lesser things, maybe like the teasing or the humiliation?
Yes, Your Honor. This statute is also too overbroad. That, like teasing and social exclusion, the statute prohibits speech that may be legal and constitutional, and therefore it sets a dangerous precedent that any speech could be deemed unconstitutional and could be limited.
How is it overbroad when it is limited by speech that inflicts physical or psychological distress on one or more students?
Yes, Your Honor. The statute does not specify that this is for in schools only, or even that it's through the use of phones, which was the compelling government interest in this case. And so it's not narrowly tailored, and it's too overbroad because it criminalizes a lot of speech, not just cyberbullying. It prohibits teasing and other speech. Like, even if I were to say a positive message, that it could be seen as, if someone were to receive it negatively, that would constitute under the statute and be criminalized.
Does the intent of the person making the statement, is that relevant, or is it in the perception of the victim of the speech? Is that the relevant inquiry? What focus should we have?
Well, in this case, the statute did not specify intent. However, that's another reason why it's too overbroad, because it's really unknown what intent that CBA had. CBA may not have had the intent to publicly humiliate the basketball team in this case, but she was still criminalized under the statute. And further, in Mahanoy, the court outlined 3 categories of speech that schools can regulate. And although Petitioner's Instagram post occurred on school grounds, it did not fall under any of these categories. And CBA was only expressing her opinion. And based on Tinker, schools should be a free marketplace of ideas where students should be able to express their opinions, and this statute directly limits this. Chief Justice Rowe, I see that my time has elapsed. May I briefly conclude?
You may.
We rest on our written brief for the remainder of our argument, and for the aforementioned reasons, this court should reverse the judgment of the lower court and find that Florida Statute Section 836.15 is unconstitutional and violates petitioners' rights to free speech. Thank you.
Thank you, counsel.
May I proceed?
You may.
Chief Justice Rowe and honorable justices, may it please the court. My name is Olivia Robbins, and along with my co-counsel, Sophia Masnikoff, together we represent the petitioner, CBA. Of the 2 issues, I will address the second issue, that the search of CBA's phone was a violation of her Fourth Amendment rights. Your Honors, there are 3 reasons why this search was unconstitutional. 1, probable cause applies in this case for the search of the phone, and this burden was not met. 2, there was no exception that allowed the search, as there were no exigent circumstances. And 3, there was no voluntary consent. Now, Your Honors, we do not concede that New Jersey v. TLO applies for the search of the phone. In TLO, it was a search of a purse, and there are fundamental differences between TLO and the present case. Now, purses contain limited amounts of information as compared to phones that contain extensive private information. And so as a result, we would contend that probable cause would be the correct standard for the phone, regardless of it being involved on school property. Now, we would also contend that the reasonable suspicion for searching the bag in the first place was not met, because the only evidence that was connecting the phone and the bag was that the bag belonged to CBA. However, there was no connection between CBA and the post that allowed for the search of the bag. Only included in the report for the cyberbullying was a selfie of CBA. However, there was no account name to ensure that CBA was the maker of these statements to connect her directly to the backpack.
Wasn't it a totality of evidence, not only those couple of things, but you had a student there, and schools are sort of insular communities where the administrators have their fingers on the pulse of what's going on and what people are saying, and it would seem like everything put together, whereas you may be able to argue each individual thing isn't enough, how about with everything put together?
With all of the evidence, there was still no direct link between CBA herself and the post, which is what would have necessitated the search for the backpack. However, even if this court disagrees and they find that the reasonable suspicion was met, the probable cause burden to search the phone wasn't met. And this is because, further, the selfie could not clearly link CBA and the post, enough so to search her phone. And this is because a selfie does not ensure that CBA was the maker of the statements. So, for example, my friend could post a picture of me, and that doesn't mean that I was the one that made that post or made the statements associated with the post. And so that wasn't a clear enough link to associate CBA as the maker of the statements, which would have been necessary to overcome probable cause to search the phone.
Do school officials need to know all of that sort of computer stuff? I mean, they're not necessarily computer experts or social app experts, but they have these bits of information that sort of focus on one person out of everybody in school. This is the person of interest here. Is that enough?
No, Your Honor, this would not be enough because even though there was a picture, it wouldn't be exactly confusing to identify that CBA was in the picture. However, that still can't necessitate that she made that post and made that statement. And so even though it is within technology, the officers don't need to have extensive knowledge of technology to know that just because CBA was in the picture, it doesn't mean that she made the statement. Further, there were no exigent circumstances that allowed for the search. Now, the state's intention was to preserve the evidence of the post and connect it to CBA. However, there was no imminent destruction of evidence because the digital footprint never goes away, and that evidence could always be preserved. And so the state could have had the opportunity to subpoena Instagram records. So even if that post was deleted, the information is still preserved because there was a link that would have been preserved that could connect the post and CBA.
But to go back to Judge Osterhouse's point, I mean, how did the school officials know that she couldn't delete it permanently? That, there are technologies that allow for remote deletion, and we don't know to what extent you can delete something permanently from a social media site. Certainly an 8th grade algebra teacher may not know that. So why isn't there good faith to try to act on this immediately and preserve this evidence?
Yes, Your Honor. There was no good faith to act on this evidence because there were still other options besides the subpoena. So the school resource officer and the principal could have accessed the other evidence in a different way if they didn't know that the subpoena was a reliable option to gain that evidence. So they could have gained that evidence by accessing the information through any one of CBA's 523 followers. That would have provided a way to access that evidence, and it wouldn't have necessitated the knowledge of knowing that things couldn't be deleted permanently. Now, according to Kentucky v. King, courts require something more than mere proof of fear of detection by the police causing the destruction of evidence, and the state offers no further proof that there was anything besides mere proof of fear of deleting that evidence. Lastly, there was no consent in this case because it's not reasonable to conclude that a 16-year-old girl would feel comfortable declining a request made by figures of authority such as a principal and a school resource officer. Now, CBA could not have voluntarily complied, and further, the school resource officer and the principal told her to open the phone, and they didn't present a real choice that CBA could have made reasonably. For the remainder of our argument, we rest on our written brief, and for the aforementioned reasons, we ask that this court reverse the findings of the 7th District Court of Appeal. Thank you.
Thank you, counsel.
Good afternoon, Your Honors. You're looking lovely as ever. May it please the court. My name is Emily Estes, and my co-counsel is Molly Donaghy. Today, we will be representing the state in this case. I will argue the first issue of whether Section 836.15 is constitutional, and my co-counsel will argue whether the warrantless search of the petitioner's phone on school property for access to private social media account violated the petitioner's federal and state constitutional rights to be free from unreasonable searches and seizure. So this statute in particular was put in place by the state of Florida because cell phones had become a disruption in the school environment. This is why they criminalized the behavior of cyberbullying, not the use of cell phones directly because that would be too broad. This was narrowly tailored specifically to the behavior of cyberbullying that is defined as the use of technology or electronic communication that inflicts physical or psychological distress on one or more students, involving teasing, exclusion, threat, intimidation, public or private humiliation, or physical violence. Now, as you can see in CBA's post, she most certainly did do that. Her humiliation, whether she intended it to be public or private, in fact did do a lot of damage, and she caused an even greater disruption. The students walking out of class, the posts that they made consequently going viral.
Does that really go to the resilience of the hearers? I mean, just because somebody says the team I'm on sucks, it doesn't cause me to drop, to leave work or to drop everything and run out into the hallway.
Yes, Your Honor, of course, but these are high school students and they're very fragile.
Well, even amongst high school students, is it normal if you hear some criticism about your team? I mean, it can come from your coach, it can come from your athletic director, it can come from fans. Is it normal that causes one to?
Yes, Your Honor. So I don't know if I'm particularly qualified to speak to what pertains as normal, but I would say that the fact that the state felt inclined enough to put this statute in place shows that this type of behavior was to be expected from something like CBA's post. This would happen consequentially, and the state was prepared for that. And I think that shows a lot that CBA, in fact, did do exactly what the statute was set to prevent, this disruption. Cell phones are disruptive. This is why this section is constitutional, because yes, it's content-based, the statute itself, but the reason the statute was put in place was based on content-neutral pretenses of just stopping all disruptions in class, not necessarily focusing on what students are saying on their phones, but how do we limit the fact that they're being distracted in the classroom.
You think it's odd that they didn't put that in the statute? I mean, if it's the intent of the statute is about just disturbing class, there's nothing in this statute about disturbing class. It talks about cyberbullying.
Yes, Your Honor. I believe that the reason they chose not to put the disruption part in the statute itself was because they cannot constitute what happens outside of school property. Like in Mahonoi, when that went to the Supreme Court, the post had taken place off of school property. However, CBA made this post on school property during school hours. Therefore, the school had a reason to interfere with this behavior, which could cause issues inside the school, in school sanctioned events, during class time, and just be overall breaking the peace of the school.
So, counsel, if the intent of the statute, if the compelling government interest here is to prevent disruption in the classroom through the use of cell phones, wouldn't a less intrusive means to further that interest be to just ban the use of cell phones in school, or perhaps more pointedly to ban the use of social media during school hours?
No, Your Honor. If schools were to ban the overall use of cell phones, that would greatly they would have to provide substantial evidence that these negatives outweigh the positives. Phones, we cannot say for certain that they are just complete evils used in school. Students go on their phones when they don't have access to computers, when they want to look something up quickly and not dig that old Chromebook out of their backpack.
Well, it's not my view or your view. Actually, it's the legislative intent that I assume it's an express legislative intent that cell phones are being disruptive in the schools. So if we take the legislative intent at its word, then why wouldn't a lesser intrusive means be just, well, let's just not have cell phones in the school?
I understand what you're saying, Your Honor. In order for the statute to be constitutional, they would have to take the least restrictive means, and in doing so, by not just completely broad banning the use of cell phones, which could cause even more disruption than what they're trying to quiet, the specific narrow tailoring of this statute to aim just at disruptive behavior that's teasing, humiliation, defamation, as stated before, that's what the state is doing.
Counsel, I mean, forgive me, but if you rewound about 15 years, there weren't cell phones in the classroom and they seemed to function. So why wouldn't removal of the cell phones out of classrooms seem to be the least restrictive means?
Thank you, Your Honor. In today's day and age, students have become very reliant on the cell phone, and it would be in the school's best interest to recognize that they're not going to be successful with such a broad ban that could also be challenged greatly on a multitude of different levels. But to just try and hit one area that they can succinctly level down, no one likes bullying. Students aren't going to argue like, well, I want the right to bully, but they might argue, I need the right to be on my phone. What if I have to contact my parents? I'm not inherently disrupting school or hurting my classmates. I simply just need to text my parent back. And we see here also that this statute itself being applied in CBA's case is not a violation of her freedom of speech, because as seen in Yusufari, the state still has the police powers to enact laws for the general welfare and protection of public safety. And in this case, we see that the students felt very strongly about what CBA had said about them, and it led them to walking out of their class and making a debacle of this, when this all could have been avoided had CBA not made the posts in the first place, and hence set forth in section 836.15. She was not allowed to make such posts of such nature. And for these reasons, we would ask the court to hold the lower court's decision against the petitioner. Thank you.
Thank you, counsel.
May it please the court, my name is Molly Donahue, and today I will be presenting the second issue in this case, which is of whether the warrantless search of the petitioner's phone on school property for access to a private social media account violated petitioner's federal and state constitutional rights to be free from unreasonable search and seizure. The trial court was correct in not granting CBA's motion to suppress data from the recovered phone. The Supreme Court left open the possibility that there could be exigent circumstances whereby a warrantless search of a cell phone is prohibited. These exceptions include the imminent destruction of evidence, to pursue a fleeing suspect, and to assist persons who are in imminent threat of injury or who are seriously injured. While CBA does not fall under the protection against a fleeing suspect or injured people, they could have easily, there is the danger that they could have destructed evidence. While they may not have been close to their phone, there are remote ways of destructing evidence. They could have had a friend log in. They had 523 followers on their private account.
Right, and that's a good point. 523 followers might have also had a screenshot or been able to preserve a record of this post, could they not?
Yes, and some of those followers may not have been willing to give forward evidence, like if it had come out, that they had snitched on it. It could cause more trouble for them personally. But that remote changing would make that evidence of theirs useless if it had been changed later. And time was of the essence to get the evidence directly from the account. So the court was also correct in their application of the two-part TLO test of reasonableness. The first part is whether the search was justified on the grounds the student engaged in criminal activity or potentially broke a school rule. This part is definitely met. There is the danger that they could have been cyberbullying, and which can also apply to criminal activity under the section 836.15. The second part is whether the search was logically linked to what officials were attempting to find. While they were presented with a partial screenshot from a seemingly reliable source, they had to verify this information and verify the evidence and link it back to CBA, showing that it was logically linked back to what they were looking for that had caused the disruption at school.
Shouldn't school officials know in this day and age that nothing is ever lost, that they didn't need to rush around here because of, well, it's out there?
Well, time again was of the essence to get the post before CBA could have changed it. But also, it is not really expected for officials to know everything about technology.
Which is fine. CBA was nowhere near that backpack, so why not call the parent who had the screenshot and said, hey, could you do the screenshot again so we can get the full picture? I mean, it seems that would be a very easy way to get the identity of the poster.
The parent was also the person who made the accusation, so they could be wanting to verify the evidence from another source or and actually directly link it back to CBA from their account, from their phone.
Wanting to verify it versus invading this very, very private, sensitive information that Riley has said has a very, very high standard before you can get to it. If you have other means available, shouldn't that be the end of the analysis?
Again, it was just before, because of the danger of losing the evidence or changing it, they needed to quickly get the evidence without going through all these loopholes or like jumping through all these hoops to get the evidence from another parent or another student or calling other students in. It was just the most direct way to get the evidence was to go through the phone. So, and for these aforementioned reasons, we would ask this court to hold the lower court's decision against the petitioner.
Thank you, counsel.
May I proceed?
You may.
May it please the court. In regards to the first issue, Florida statute section 836.15 was in violation of the First Amendment's guarantee of free speech. The court in Tinker v. Des Moines Independent Community School District put it best when they wrote, "Undifferentiated fear or apprehension of disturbance is not enough to overcome the right to freedom of expression." The government has no right to limit the fundamental right to freedom of speech because of what was not a substantial disruption when only some students walked out of class. Now, in regards to the second issue, the search of the cell phone was unconstitutional in violation of the 4th Amendment. Respondent is asking that we equate the search of a purse to the search of a phone. And according to Riley v. California, modern cell phones are not just another technological convenience. With all they contain and all they may reveal, they hold for many Americans the privacies of life. The probable cause that should be applied to search phones was not met in this case, as there was no clear link between CBA, the post, and the account. And further, the trial court based their decision on the fact that searching the phone was the only means of gathering the evidence. However, it was not. And time was not of the essence, as the records will always be present and available, and there were no exigent circumstances. Reverse the findings of the 7th District Court of Appeal and find that the First Amendment and the 4th Amendment were violated. Thank you.
Thank you, counsel. Thank you all for your arguments today. This court will adjourn.